Yes, tell me.
Lordship, I beg to mention item number 30. I beg to mention item number 30 with the consent of the other party. Matter taken up to
Yes,
2 weeks. Item number 30.
30.
Lordship,
30. Yes,
after 2 weeks. Matter.
at the request of the learned counsel for the petitioner, matters and adjourned to be listed after 6 weeks.
2 weeks.
No, sorry.
I mean,
Next year, I think.
unusual prayer, Lordship.
Yeah.
Item number 60, 61, 62.
Huh?
Item number, last item, Lordship. 60, 61, and 62, Lordship. Can it be upgraded, Lordship? It will be, we have considered their prayer. Stay is
Item number?
60, 61, and 62. We have
60.
considered their prayer, Lordship.
Okay. We'll do one thing. Once we finish up the motions, we'll take it up.
Another prayer, Lordship. Item number that is also against us. It will 42, Lordship.
What is that?
This is AFDC. This is department. This is AFDC. This is also stays operating again. It up to, Lord.
No, that I won't. But these, you are considering it, and you mentioned these matters yesterday.
Yes, sir.
So we will take it immediately after the motions. এটা টিকারেটা লাগাই দিবা
42 to 42, Lordship. Can it be stays operating for 1.5 years, Lordship? 42, Lord.
We'll take it up at 2.
Yes, oblige.
Or we do one thing. 42, 61, all these things, we'll take it up at 2. Okay?
Highly oblige.
Lord, I beg to mention for orders.
For orders?
List.
Why? What is the urgency? What have you done?
Lord, the matter is with regard to construction of EMAYG house. The notice has already been received by the other side. The matter was last posted on 18/9/2020, and it was supposed to be listed after 4 weeks. But since then, it has not.
It will be listed on 6th of December.
May I please, your Lord? My Lord, on behalf of the petitioner and with the consent of the other side, may I beg to mention item number 51?
Yes.
Let it come, my Lord, after 2 weeks, because instruction is awaited for filing
They
affidavit.
have informed the other side.
Yes, sir.
At the request of the learned counsel for the BTC, the matter stands adjourned. You have filed your affidavit.
I will file, ma'am.
Matter again adjourned and to be listed on 3rd of January 2023.
Interim order may be continued. Item number 50.
3rd of January 2024. In the meantime, the BTC shall ensure, the council shall ensure that the BTC files the affidavit in the matter. The interim order passed earlier shall continue till the next date. Yes, Mr. R.R. Gogoi.
Lordship, with the consent of the other side, I beg to mention item number 53, Your Lordship.
Yeah.
In this matter, instruction will call for the verification report that's still being awaited, Your Lordship. Had the matter be taken up after 1 week, Your Lordship?
No.
You have taken consent the other side.
Consent, no consent, I don't know. Yeah, it is a question of compliance.
Yes, Your Lordship.
We will
Yep.
see what the compliance is.
Very well.
On
Okay.
them matter, yes. Next.
I beg to mention three petitions for admission. These are matters regarding NREGA. The petitioners have not received any employment during the year 22-23.
When did is the service complete?
Yes.
Service is complete?
Yes.
Okay. It's the matter for admission on 11. Matter will be listed on 11th. 11th.
May I please, Your Lordship? Lordship, with the consent of other side, I beg to mention item number 18. Listed for admission. My senior, Mr. Chaudhary, is out of station. Mr. Gautam Chaudhary.
Item number?
18, Lordship.
Sorry, it has come by order.
Yes, Lordship, we mentioned
No adjournment. Next.
yesterday he make a mention. that
I
he will
can't
be out
help
of
you,
station.
madam. You have by order mentioned. I will impose a cost of 10,000 minimum. I'll adjourn it because you have mentioned it before a court. Like today, you have 5 minutes have already gone in these matters. You mentioned it and the matter has come and now you don't want to do it. Can't happen like that.
Lordship, it so
5,000?
happens- It so happens that Mr. Gautam Chaudhary.
Sorry. I didn't mention the matter. We'll take it up. We'll see what can be done.
May I please, your lordship, I beg to mention for listing a motion, your lordship. Listing a motion, your lordship.
Hmm.
Uh,
What is the motion? When did you file it?
Is the,
Then why do you want it?
use the lordship.
Why?
Lordship, urgency is that, the PTCS has, supposed to disconnect my, electricity connection. It is the,
Is it? So why do you need it on Tuesday? We'll have it today?
lordship.
Today.
Obliged, sir.
My lord, I did mention for listing for admission, my lord.
Why?
My lord, urgent matter, my lord, very urgent matter, my lord.
What is this urgency?
Ration card, issuance of ration card, my
Ration card.
my lord.
Okay.
Only
6th of December.
Well, I have similar pair listing for admission, my lord. It's matter regarding my lord, assisting of a IMFL shop. 2018 matter.
So?
Next week, my lord.
You are for whom?
I am for the private, my lord. I am for the petitioner, my lord. We are against the listing of the IMFL shop,
You got a
among
stay,
the-
Mastuli.
my lord.
Have you got a stay?
No, my lord.
Then you must have shifted in the meantime.
My lord,
2018.
the issue is that they have shifted the IMFL shop in the residential area, which we have objected, being the development committee of that locality. My
Who has objected?
we have objected
Okay, then
the residential
it is continuing.
continuing, my lord.
Let the New Year's go. Thereafter you go. Why New Year's you want to spoil that?
Two times it is listed,
No,
but
no,
not
no.
reached.
This is nothing. There is no urgency. Okay. 13th of December.
Well.
Give you a good date.
Obliged, man.
For withdrawal, item number 1.
Simple withdrawal. Learned counsel appearing on behalf of the petitioner submits that he has instructions to withdraw the instant writ petition. Accordingly, the writ petition stands closed on withdrawal. Full stop. Interim order, if any, stands.
Second,
2.
Interim.
Same.
नाम तो DTPT S नाम.
obliged.
Item 3 for Musharraf.
Yes, I didn't want to issue notice. Now tell me, why should I issue notice? You have not filed your affidavit. Also.
Lord, here we have not got the complete information actually. We got information from only one person.
Yeah.
There are 6, 7 petitions. So if you're
Then file it properly when you get your information. Withdraw with liberty to file it properly. This is not the manner you file it. You don't have the information. Your basic case is under section 73, 79. So 79, the question that this court is not satisfied. You want a dismissal, I can dismiss it. That can I go. But I think you better withdraw and file with the liberty file again.
Lord, kindly done.
Mr. S.J., the learned counsel appearing on behalf of the petitioner submits that certain vital facts, material facts is further, certain vital facts is also required to be brought on record, for which wholesome amendment would be required to the petition. So he therefore submits that instead of that, he would like to withdraw the instant writ petition and file a fresh one. So taking into account the above, the instant writ petition stands closed on withdrawal. However, liberty is given to the petitioner to refile.
Much obliged.
For same. You don't have a right as regards the others, that's all.
This matter can it kindly be passed over to the time?
Why?
My Lord, I'm
You sought for you filed the additional affidavit. Good.
Yes.
Laggy. Yeah, it is your case, as I could understand on the last occasion when Mr. Botago was submitting, is that they have not followed the procedure in making the assessment as per section 79B. That's your case. You don't know. Okay. What do you want? I am being.
Applied.
Yes, what is your case, Mr. Barbuya?
May I see the lot?
What are you
Lord,
asking for?
Petitioner before your lordship is the.
Set
my lord,
aside an
contractor,
impugned
my
bid
lord.
acceptance letter issued by Iman and the conditions of impugned so and so passed by the general manager may be set aside. Yes, why?
My lord, here, my lord, the petitioner, my lord, wrongly submitted tender, my lord.
Who?
Yes.
The petitioner.
Petitioner, my lord.
And then?
Lordship, kindly will look page 41.
Yes.
This 41, my lord, this is for Sidan car, my lord. He had to submit, my lord, this, my lord, 3,480 into, my lord, 588 days.
Hmm.
But he only quoted, my lord, day. 1 day, my lord, price he quoted, my lord. But surprisingly, my lord, they took, my lord, this is the whole amount, my lord, for 588 days, my lord. And right hand side, my lord, kindly have a look page 41. And they are asking, my lord, accepted my tender to give the, my lord, the vehicle only, my lord, 5 rupees.
Where is that order? Which are the impugned orders?
Yes, my lord,
Acceptance.
impugned order, my lord, page, my lord, one order, my lord, page 54.
So your case is that you have wrongly
Yes, sir.
submitted your quotation
Yes, sir.
and now they want that you should do it.
Yes, yes.
Now, if you don't do it, the question will be forfeiting the earnest money deposit.
Yes.
So in a way, you are contemplating that your earnest money deposit would be forfeited.
Yes, sir. And
And
other
therefore
losses
you
also.
want to withdraw. Yes.
Other losses also, my lord, page 57, my lord. If, my lord,
Yes.
it is provided, my lord, undersigned in exercise of the power as contemplated in the MTF.
Terminates the tender for hiring of so and so with immediate effect besides forfeiture of the demand, and the corporation shall go for appointment of another contractor to get the work done for the unexpired period of the contract with risk and cost, and to claim from Nizon any resultant loss sustained or cost incurred by the corporation.
Lordship,
So
kindly-
you are against that.
Yes, my lord, page 19, my lord.
Okay.
They-
No. Show me as per the tender conditions how, what happens if you don't do it.
Page, my lord, 19. Page 19, my lord, clause 7, my lord.
Hmm.
As per this clause, my lord, they are not bound to, my lord, this third, my lord, tender to accept.
Mr. Borbuya, don't make that submission. Better submissions are there. Better submissions are there. Make it. Let us see where is the provision by which if you don't pursuant to an acceptance of tender, because you have not entered into an agreement till now. Have you entered into an agreement? No. So if upon issuance of the letter of acceptance, if you don't do, can the imposition of risk and cost be there or not? Let us see that. Where is that?
It is clause 1.
Yes, clause 12.
20, my.
Clause 12. No. What is that 20? Let us see what it terminate.
Twelve also. Page 25, my lord.
So the EMD shall be forfeited as per 12. But as regards the risk and cost, we state. But as regards EMD, you go ahead. That is only the win-win, Mr. Bolbhuya, you have. Nothing more than that.
EMT, I think he under being a MSME contract, he has not furnished any EMT, man.
No,
I have not implemented any.
that is why you are not
That's why they
saying.
are
But
taking-
why have you in your order said EMD? EMD will be forfeited. That is what I am asking.
So, by issuing the acceptance letter, we have asked him to provide the security deposit and bank guarantee. Since he has not furnished the security deposit and bank guarantee in time, so we have issued this termination letter that it will be
Let
issued
us
in
see
the
the termination letter again.
Page 54, my.
No, no. Yeah, the order.
operative part is at
Page
page 57.
54.
57, my lord, last paragraph.
Whereas so and so, whereas as per the remark for hiring of chicken and men and women and see the letter of acceptance.
Letter of acceptance, my lord,
Page
page 41. One, my lord. And another, my lord, page 61.
yes, Mr. Bolbhuya. What is your case now?
My lord, 5 rupees, my lord, 91 paisa per day vehicle, my lord,
But you have been asked to pay 50,000, although your lump sum of the contract is 4,800.
Yes.
Why security deposit of 50,000 is required?
It is as per the MTF, my lord.
Huh?
As per the MTF, my lord. Model tender form agreement, my lord.
Hmm.
And this termination letter was issued in pursuant to the clause 20 of the MTF, my lord. Model tender form at page 27. Since he has refused to do this contract, so it has
Page
been
53, my lord,
terminated.
my surrender letter.
Wait, page 27.
Page 27 down below clause 20.
Page 26.
27, my lord.
Yeah.
Termination. Clause 20.
Huh?
Clause 20, my lord. Down below termination.
Huh.
In the event of the service provider having been adjudged insolvent or going into liquidation or winding up his business or making arrangements with his creditor or failing to observe any of the provisions of this contract or any of the terms and conditions governing the contract, the FCI shall be at the liberty to terminate the contract forthwith without prejudice to any signature of service provider.
No, without any prejudice to any other rights. Any other rights or remedies
Any
under
other
the
rights
contract
or remedies
and the law
and the
to get
contract
the
and
work
law
done
and to get the
for-
work
for-
done for the
yeah.
unexpired period for the contract under risk and cost and to claim the service provider any resultant loss sustained or cost incurred by the corporation. So, my lord, we have issued another tender. If that tender, a successful tender comes in this contract, my lord, if any extra cost we have to bear, that will be at his risk and cost. That is the meaning, the risk and cost.
And he has not paid the EMD.
He has not paid TM. Being an MSME
My
contractor.
application, my lord, page 53, my lord.
Page
Page 53, my lord. He was
My lord, after issuance of the acceptance letter, he has come with this letter
he
to
was my lord loan tenderer. my lord.
Huh?
He was loan tenderer. my lord. About the LFIR.
since we have not blacklisted, they might have again appeared in this new tender, my lord. They have bidded in the new tender also. They are the regular tenderer. I think so.
we issue notice.
Only
Uh,
notice may be issued, my
No,
lord,
no.
because risk and cost factor will only come at the end of the contract, my lord. The contract will be for 2 years. So meanwhile, this decision will come, my lord. We will file our affidavit in office. Because risk and cost factor only come at the end of the contract, my lord. New contract. That is 2 years. After 2 years. Because
You have already started the tender.
yes, my lord.
Retender already issued.
And you have participated.
No.
You are not going to participate.
All respect, my lord. I have to submit my lord.
Notice may be issued, my lord. We will file our affidavit in office.
Accepted my tender, my lord. For 5 rupees per day. my lord.
Issue notice making it returnable. By when can you file your affidavit?
Within 6 weeks. After 6.
Issue notice making it returnable on 3rd of January 2023. 24. Mr. B.K. Singh appears on behalf of the
Okay,
respondent numbers 1 and 2
One and
and Miss you and
three.
Ms. Yudas appears on behalf of the respondent number 3. Why are you making the respondent number 3 unnecessarily? 1 and 2. Full stop. The learned counsel appearing on behalf of the petitioner submits that taking into account the issue involved, the presence of the respondent number 3 would not be required Taking into account the above, the name of the respondent number 3 is struck off. The petitioner is directed to serve and file a fresh memo of parties before the registry by 28th of November 2023. The registry shall, on the basis thereof, make necessary correction of the records as well as also update the same in the CIS. Mr. B.K. Singh, the learned counsel, appearing on behalf of the respondent number 1 and 2, having accepted the notice on behalf of the said respondents, the petitioners is directed to serve extra copies of the writ petition by 28/11/2023. This court have also heard on the question of the interim prayer. The learned Mr. B.K. Singh, the learned counsel, appearing on behalf of the respondent number 1 and 2, submitted that pursuant to the termination of the contract with the petitioner, the respondent authorities have already initiated a fresh tender proceedings. The imposition of the said risk and cost upon the petitioner would be only upon the period of the contract, fresh tender, period of the contract on the basis of which the fresh tender has been issued would come to an end. The learned counsel for the respondent number 1 and 2 further submits that the petitioner, being an MSME, had also not submitted any EMD as the same was waived. It's waived
Yes,
or
it
it is not
waived.
necessary? Which one is it?
I will find it out.
As the same is not, and had also not, being an MSME, have also not submitted the EMD. So taking into account the above, this court is of the opinion that the question of deciding, the question of passing an interim order at this stage does not arise. However, liberty is given to the petitioner as and when there is a demand of the risk and costs. The respondent 1 and 2 shall ensure that the affidavit is filed on or before first, second of third, no, I mean 5th video, 5th of here, filed on or before 3rd of January. Very bad is
6. Obligement.
yes, non-payment.
Yes.
Non-payment of what?
Contractual bill.
Writing, printing. Did I dispose of a similar matter that day?
Yes, Father.
Etu koi dibo hai? Ine dichu printing ration card.
Yes.
E date kita di dibo ha. Etu order. Then bill dise. Etu dise. There's a sanction has come. No sanction.
No, sir.
In this case, etu case of sanction nai. Etu case of sanction na. Ha. Aru teke te pio. ঠিক আছে এই দুদিন আগতে হইছে
WBC number মিলত 6696.
dispose.
Seven.
Non-payment of the construction.
Hmm?
Non-payment of the construction bill. Construction tender, I participated. And accordingly, I was the lowest bidder. Formal work order was issued by February 35, my lord.
My lord, admittedly, it is there. Completion, work completion is there and only no fund.
But anyway,
I-
you make verification.
There
Because
was a-
unnecessary, because you see why I thought of, I may issue notice. You may one fine day, as per your ledger, give the information. Say that yes, some amount is payable, and you see the officer in the lowest rung will file an affidavit at best. And at the time when he files the affidavit, then also on that basis, this court can pass an order.
my lord will grant us some time and
No. I'll do
No,
one
no.
thing. I'm disposing in the,
This-
giving you,
my lord,
this
my
is which one? PWD.
no, my lord, this is tribal
Private
appeals.
So this is 6 months.
My lord,
Verify and pay. এইটো সেইদিনা এটা কথা এই আগৰ অৰ্থটোৰ নিচিনাই হ'ব I'll dictate it with your presence because unnecessarily earlier to একে আছে The instant repetition is taken up for disposal at the motion stage. The petitioner herein is the proprietor of a firm in the name and style of MS Gem Enterprise. Pursuant to a expression of interest issued by the respondent number 2, dated 19/12/2020, and thereby inviting experienced event management firm /NGO for organizing inverted comma ethnic tribal tourism festival of Assam inverted comma close eco tourism festival 2021 in the district of Kamrup, Jorhat, Dima Hasao and Kachar under the budget head of inverted comma ethnic tribal tourism festival of Assam during the financial year 2020-21 at the 4 different districts of Assam. Full stop. It further reveals that pursuant to the said tender process, expression of interest and the participation of the petitioner, a work order was issued by the respondent number 2, bearing number DW/Tribal Tourism/1108/2020/30/5465 dated 27/1/2021, awarding the work of Eco Tourism Festival 2021 in the districts of Kamrup, Jorhat, Dima Hasao and Kachar during the financial year 2020 and 21 to the petitioner. It is the case of the petitioner that the petitioner duly completed the work as per the said work order, and a completion certificate was also issued on 22/2/2021. The petitioner had also submitted the bills before the respondent number 2 for payment of an amount of rupees 199.42 bracket rupees 1 crore 99 lakhs 52,000. 1,99,40,000 to the petitioner, but the said amount have not been released. The petitioners thereupon have represented before the authorities time and again. It is also relevant to mention that the respondent number 2, by the letter dated 19/1/2021, had submitted a proposal for financial sanction of the said amount to which the petitioner claims herein during the year 2020. Petitioner claims herein. It is also seen that the petitioner have been also issued. It's also seen from Annexure Roman 7 that the respondent number 2 had also issued a form of utilization certificate certifying that the scheme, namely Ethnic Tribal Tourism Festival of Assam, is a new scheme and no fund has so far been sanctioned during the financial year 2020-21. It is the case for the petitioners that in spite of the clear-cut admission on the part of the respondent authorities that the petitioner is entitled to the amount so claimed, the respondent authorities, for best reasons, have not paid the amount. Full stop. It is under such circumstances the instant writ petition has been filed. I've heard Mr. Ardhor, the learned counsel, appearing on behalf of the respondents, all the respondents, who submits that the actual entitlement of the petitioner can be, who submits that although from the perusal of the materials placed by the petitioner on record in the writ petition reveals that there has been certain, there is a communication issued by the respondent number 2 to the director, to the deputy secretary to the government of Assam, WPT and BC department, submitting the proposal for financial sanction of the amount so claimed by the petitioner. But the said aspect has to be verified at various levels. He therefore submits that the instant writ petition be disposed of with a direction to the respondent authorities to make verification as regards the entitlement of the petitioner. And upon verification, if it is found that the petitioner is entitled to the amount so claimed or part thereof, the same be released to the petitioner within a time-bound period. This court, having taken note of the fact that there are certain communications which shows, taking note of the above facts, is of the opinion that the instant writ petition is of the opinion that the instant writ petition can be disposed of at this stage itself. So accordingly, this court therefore disposes of the instant writ petition, directing the respondents herein, and more particularly the respondent number, the principal secretary. No, one, because two has already given. More particularly, the principal secretary to the government of Assam Tribal Affairs P department, to make either by himself or through his delegate, make verification as to the actual entitlement of the petitioner. If it is this court further directs that if the amount is found, if it is found that the petitioner is entitled to the said amount or any part thereof, the said amount be released to the petitioner. The said exercise be completed within a period of 6 months from the date of submission of the certified copy of the instant order to the principal secretary.
Along with the copy of the writ petition.
Why?
Okay, it is in motion.
Why do you read petition is required? You have to verify.
Why?
Why do you need it?
Item 8.
So the respondent number 2 is also directed to aid the principal secretary, Tribal Affairs, for the purpose of carrying out during the purpose of for carrying out the verification as directed herein above. Yes. What is this?
My lord, this is regarding non-payment of the bill, outstanding amount.
How much?
Rupees 20 lakh,
Where is it amount? Mentioned in your petition?
my lord. Seven. 6.
Where have you mentioned?
Para 7.
Huh?
Para 7.
Plus 7. Why have you not mentioned in your prayer? We dispose it of. Make verification and pay. Ito likhi dibo, ha? Hey, agor itu no ta agor tu nikhat type le likhi dibo. Then invited tender kore to hall. Kalto itu 20 lakh kam koile 20 lakh to kap kale. However, representation this way, the not payment then, and as such he has filed. And Mr.
And Anand.
Anand
RK Musari.
R.K. Musari appear করছে ইয়াত. And Mr. Who is appearing for whom?
I'm responding 2, 3 and 5.
Give your names, huh?
RK Musari.
All are represented, I suppose.
Lordship, I am appearing for one lot.
Accountant, Jhala Development Block, Junior Engineer, Jhala Development Block.
2, 3, 4, 5, 6 BTC Lordship.
So it will be the BTC will be.
It,
And who will be the person who will verify?
I mean, the director.
Huh? To whom should we direct? Irrigation can't pay. It will be directing the secretary.
Secretary.
Secretary Board Council, either through himself or through his delegate, shall make the verification and so on. Mr. P. Naik, you appear for?
One department.
And why is the financier?
Finance is not there, Lordship. It has been wrongly.
Wrongly shown. Finance 90. Mr. You appear for irrigation.
One, yes.
Irrigation.
Earlier part.
Mr. P. Naik submits that the Learned Standing Council for the Irrigation submits that as the said subject is a transfer subject,
Yes.
as such, it will be the BTC authorities who would be bound to make payment and not the state of assignment,
Earlier.
not the irrigation department under the state.
9.
They are submitted, huh?
Yes.
Yes, what is this?
It's to tender. Lordship.
Yes, tell me what is this? Impugn cancellation order dated 10/8/2000 issued by RESCO whereby approval for mining contract made in favor of the petitioner in respect of area has been cancelled. Yes, why has it been cancelled? Who has cancelled?
Respondent number 7.
Who is 7?
DFO.
Lordship,
DFO. This is transferred, BTC.
BTC.
Yes, why have you cancelled it?
Lordship, that instruction I need, but he has submitted his application in wrong form, Lordship. He has to submit his application before the respondent number 5, Lordship.
Let us see where is it is mandatory to prepare and produce the approved mining area along with the environment clearance before any operation of extraction. Whereas notice was served to you to submit the requisite approval along with notice of area within 7 days from the one failure to set one year of submitting. Now, what is wrong with this order?
That has been forwarded to DFO. Man.
Huh?
Forwarded to DFO. That has been.
Forwarded to whom? Now, this is you are challenging page 66.
Page 66 cancelled.
You're challenging. What is wrong with the order?
At that time, petitioner could not get the environmental clearance. Thereafter, issued a notice within 7 days. And after
You want to stay?
Yes.
You want to stay? Okay. But the royalty you have to deposit. You get the money. Win-win for you. You want the money. You only problem is the money. You are losing the revenue.
Within the revenue, but some probabilities is there, Lordship. He has to fulfill within time, Lordship.
Give him more time. But what is your main problem? Your problem is the money.
To earn
You are not losing. Because his mining contract, you keep on paying.
Yes.
And get whatever you left. What is win-win?
In the meantime, he still.
And if you first stop paying, then the cancellation order will come in. In-time order stands vacant. Isn't it? Settlement has been made as per. Because your question is that you have duly submitted. The environment member secretary have not given.
Yes.
And as such, you can't cancel it. Very, very true. But the fact that he is entitled, you can't deprive the state of the revenue. Where's the order by which you had to get it?
Six. Tender, page 26.
Page
26. Annexure two.
26. Tendered amount quoted,
No.
demand.
8 lakh.
CFO letter.
This is for how many years?
5 years.
5. Huh? 5 plus 2, 2 plus 5. Or what? Where's the order?
7 years.
2 plus 5 it will be.
Sale.
Sale notice. And where's the order? No, where's the order?
Page 29,
Inform me that the Boroland is pleased to approve the competitive settle the concern for
Page 14,
granting of
annexure.
mining contract with the successful to the correct segment. And what are the terms of approval?
5 years.
Like to inform you that you are hereby asked to pay and submit the mailing contract per year.
2 years to करने लिखेंगे ये
And how do you get the royalty? You pay the royalty, na, as per this. Kindly come to page 26, Mr. Gogoi. Kindly come to page 26 and show one page.
22.
8 lakh.
This is the
51
amount.
8 lakh.
Earnest money deposited, yes. Tendered amount is 8 lakh 51,615. Tender, yes, yes, yes. But at what price it has been fixed, given to him per year?
per year. 5 lakhs 74,000.
Huh? No, that is the reserve price. Because this code will direct him to deposit that amount.
28,000.
He may delay whatever. That is the ground of stay. What will be the kist? We do one thing, madam. We'll have it on Tuesday. You get what is the kist spell. Okay.
Schedule of the case. Schedule of the case.
Yeah, that you get it. Or Wednesday. Or schedule of the case. Then what will happen? We'll stay subject to depositing the kist. And if he fails, they go. Because his only thing is, then look here, I have submitted the mining plan, I have not got it. But then also the state can't lose. List the matter. I don't issue notice. I don't say anything. You get that value. List the matter again on 29th of November 2023. For motion. And you, Mr. Counsel, you also obtain your instruction. Are you ready or not to pay the kist?
Item 10.
Yes, Mr. Khan.
My lord, page 48, my lord. Annexure A, this is impugned, my lord.
Annexure A.
My lord.
Clarification regarding notification in connection with the department that I am directly informed that he was held on one. Yes, then
They have included, my lord, private agencies. I am an individual. I am constructing my own residential building, my lord.
oh, that one. I passed some order. You have got an order?
My lord, other cases order, your lordship's order I have not got, but other orders I have annexed wherein this has been stayed, my lord.
No, I passed an order.
Page 32 onward, my lord. Page 34, my lord. This has been stayed, my lord. Page 34. Till returnable date, the operation of the impune communication dated 2/3/23 shall remain suspended, my lord. Lordship order I have not got. Just search for it.
I am a temporary to bench force, so you must have thought that why necessary to take his order.
No, my lord. I had no knowledge, my lord.
You may have got some order for settlement and all, but not here.
I am sorry, my lord.
Anyway, you should notice making it returnable on 5th of January 2023, 24. Mr. What is this petition number 1? Respond number 1. Who is respond number 1?
Commissioner and secretary, my
There's
lord.
another mistake, my another mistake, page 18, Lord.
Page 18. Yes.
Notifications went to, it is 17/2021. Annexure 18, correct.
Annexure 8.
Second one. Index also column 10.
And what is this type of petitions?
My lord.
I can't spare this. File it properly. No, this is not done. How do you file these type of things? You are a bit responsible. If you were a junior lawyer, I would have given you some liberty, but not to you. The learned counsel appearing on behalf of the petitioner submits that as there are certain formal defects which he would like to correct it, he submits that he would like to withdraw the instant writ petition and refile with the liberty and refile and seeks a liberty to refile by removing those defects. So taking into account the above, the instant writ petition stands closed. However, liberty is given to petitioner to refile by removing those defects. Properly. And what is this commissioner and secretary? How you see the problem which arises is I have to strike off one. And thereupon, you see, once I strike off, now earlier it was okay. Now, once I strike off, I have to ask you to submit an amended memo. Then the registry has to correct. Again, it goes to the CIS. The CIS has to correct. Everything goes. Oh, it becomes very difficult.
We'll correct it.
11, file a fresh one.
My lord. Okay.
Yes,
seeing the
Mr. Thor.
Indian order at page 118.
What are you asking?
What is the
Quashing the impugn order dated passed by Iman on the ground that the respondent number 2, without going through the documents furnished by the petitioner as well as without appreciating the judgment and order oral dated Iman passed by this. What is the judgment and oral? Oral
page
page?
108? Lordship's order.
Oh, my order.
Yes.
Why have you mentioned oral?
Lordship, it was judgment and order oral, Lordship.
Yeah, then tell me, what is it? What did I say?
Paragraph 12 and 13 is relevant.
12 and 13. Is this matter of the Apple and Council bill that appeals from the judgment? The specific petition you Yes, then,
Lordship, then this imperial order has been issued for.
hmm?
Imperial order has been issued on
In pursuance to the remand part.
11/18.
Who are you? Second party? Kushal
And
Bauri. Who is Sankarlal Bauri?
Sankarlal Bauri is the petitioner. Who is
No, he's not a petitioner.
He's-
Here you say dead. Your petitioner's name is Kushal Bauri.
Kushal Bauri.
Then who is
Sankarlal
Sankarlal?
Bauri is my father-in-law.
Your father. Yes, what is wrong?
Private restaurant number 4 was all alone a tenant of mine.
Huh?
He was all alone a tenant. Lord.
Who?
The restaurant number 4, private restaurant number 4.
Then?
And if your lordship comes to page 27A, this is the lease deed of by the Dibrugarh Municipal Board and Sankarlal Bauri Lord of the year 1995.
Then?
They enter and if your lordship comes to the schedule at page 30, the schedule referred to above, all those piece or parcel of land.
Now, both the persons executed lease agreements with the Dibrugarh Municipal Corporation.
Lord.
Now,
the response number 4 never, lordship has in your lordship's order, judgment, at page paragraph 12, lordship has it is a state we grant to press lease deed dated 1/3/2019. The state is made out by 15 in the issue of that lordship has already set aside that lease deed.
no, I have that lease deed has not been taken into consideration.
No,
Date of execution of lease deed along with the term. That lease deed has not been taken into consideration. That has been set aside. Then Sankarlal Bauri on 31/8/1985.
Yes, Lord.
The RDs at page 119, the reference which have been mentioned as regards the date of execution of the lease deed
Lordship.
are between whom?
Lordship 1/10/2019, Lordship.
This is with Dibrugarh Municipal Board
Between Dibrugarh Municipal Board
for 15 years.
15 years.
Yes, then
But there was no lease deed between the Dibrugarh Municipal Board along with the MS Datta brothers. And the lease deed which was executed on 1/3/2019, that was set aside by your lord.
no, that has been set aside. It's okay, but have they mentioned about that the lease deed? Anyways, I think we can just issue notice, nothing more than that.
Lordship, in the meantime, the empty note may be stayed.
Absolutely no. They are possessing, that is the status quo is to be maintained, which is being mentioned. Let us look into it. And in fact, these are all private disputes. Why should we? What do you say, Mr. Sharma?
Otherwise, Lordship, in
No case for issuance of notice?
Lordship, if your Lordship comes to your Lordship judgment, the last paragraph, your Lordship has directed them to hear both the parties and thereafter pass an appropriate order. And from this order, it reflects.
Because this court did not touch anything
Lord-
except interfered with the lease deed
Yeah,
which
yeah.
was there.
Yeah.
But the order does not show that on the basis of that interfered with lease deed, that was any decision was taken. Then, okay. Keep this matter pending for another 10 years. Issue notice making it returnable on 10th of January 2024. Mr. H. Sharma appears for respondent number 1.
1 and
One.
3. Three
One.
executive officer.
Huh?
3 Lordship executive.
Can you appear?
Lordship, I have been told that I can appear.
Then also for 2.
No, not for 2.
Why?
Executive officer, municipal court.
No.
Lordship, no.
You can't, because 2 and 3 has to be appears for respondent number 1. The petitioner is directed to serve an extra copy of the writ petition upon Mr. H. Sharma by 28/11/2023. As regards the respondent number 2, 3, and 4, the petitioner is directed to effect steps by way of registered as well as usual. You want to do it by dusty?
No.
The petitioner is further given the liberty to take steps by way of dusty, routed through the registry of this court, and file an affidavit of service on or before the next date. The learned counsel appearing on behalf of the petitioner further submitted that the order which had been passed, that the impugn order dated 11/8/2023, which has been assailed in the instant writ petition, is required to be stayed pending disposal of the instant writ petition. It is the opinion of this court that taking into account the opinion of this court that taking into account the directions which have been passed in the said order to the effect that both the parties shall continue to remain in possession and occupation upon their individual site premises. This court would not like to disturb the same without hearing the respondents. The interim order shall be considered upon service upon the respondents.
12.
Yes.
Dr. McKinley, see, page 77 is the impugn order. The deputy commissioner declined to
Yes.
The deputy commissioner has declined to grant license on the ground of pollution. There will be pollution. Now let's look at this page 68.
Where?
Page 68.
No, where is the decision that he is prohibiting on the ground of pollution?
Impugn order, my.
Where
Page
is,
15. Page 77.
yes, tell me, show me, where is it?
There is the report of public hearing conducted by Circle Officer, Knockout, report was sent to, wherein large number of people opposed setting up of the proposed MS on the ground of pollution.
That is the report. That is the report which is being perused. See the next line.
Hence, I explained to Sensu, Naga have prohibited, to Sensu, other order, provision under section
So he does not give any reasons.
Well.
There are two reports. One report whereby the circle officer says that the petitioner has all the documents. Number two, the circle officer another report wherein the public says that there you should not allow on the ground of pollution. These are the two reports.
Good.
Then he does not give his own decision. He says that I prohibit.
now is
Or am I making the case for you?
now is page 68. Pollution control got already permitted. Page 68, my lord. It is relevant.
Yes, we are paying for the district
Consent to
commissioner.
stabilize, then consent to operate.
We have to get notice because notice and not only that this question of stay does not arise, but the thing is you get your instructions. That is the only way.
Well, only page 11, 68 district. Pollution control board already give a certificate that there will be no.
Mr. Council, if you want to render me to the status of a district commissioner, that is, it is within your perspective to do so. But otherwise, I don't want to. So I can't therefore direct that give them the permission. The permission has to be given by the district commissioner. And I can't do so without hearing the other side. So let me give them a notice. And on the next date, we'll do it, provided I'm sitting.
Hello, and with an observation
For what?
that deputy commissioner may review his order because he.
No, I'm not. That will be fine. Why should I? May, what it is May business? May. There's no May business. Anyway, issue notice. There are a lot. And why have you not made the people who have submitted the
No, no,
representation a party?
I give the report. All the people submitted in my favor. 2 persons only objected.
So you know who are the two persons?
Yes, yes, I annex that resolution.
Absolutely. Why haven't you made them parties? Why? You know there are two persons. I would have understood hundreds. It's a different thing. So there are two persons. Why haven't you made them parties? You should hear them also.
Then I will be allowed. I will also make them party. And if permitted to make them as party.
Withdraw with liberty to refile by making them parties. Because unless you say it will become useless. That is the only way out. You see what will happen. This court can't issue notice now. If this, as of now, your petitions is bad because without hearing them, without them, what do you say? Okay. But I will make an observation out here that you have not made those two persons a parties. So that is why I am not considering your interim.
Well, then I will amend the petition or
Amend is again another big problem.
I will refile.
Refile. Mr. J. Ahmed, the learned counsel appearing on behalf of the petitioner, submits that taking into account that the report, the order which have been impugned in the instant proceedings have been impugned in the instant is being passed at the behest of two persons who had objected, whereas the other people in the public have duly had objected. The petitioner would like to make them, implead them also as parties to the instant writ petition. You say,
Also, Gavura, I will Gavura and other.
they would like to. You would also like to implead the Gambura of the concerned village as a party to the instant proceeding. He therefore submits that instead of filing appropriate applications for the purpose of impleading them, he would like to withdraw the instant writ petition with a liberty to refile by removing those formal defects. Taking into account the above, the instant writ petition therefore stands closed on withdrawal, full stop. The withdrawal of the instant writ petition shall not preclude the petitioner to refile, to file afresh by removing the formal defects.
And I may want to make other persons as party is connected.
Whomever you.
13.
Yes, Mr. Purkayastha.
First, regarding shifting of IMFL block.
From where to where?
Uh,
You are challenging.
Yes, I have been directed to shift my shop.
Okay.
Imperial order is page 33 lot. This is
Page?
first 33.
In the public complaint and inquiry report submitted to the in the range of 100 meter of fence. There are two Kali Mandir on Friday. Yeah, tell me.
What if you're stating that he hasn't put it in
Does the Supreme Court judgment
Yes,
still
Your Lordship,
apply?
that was modified, Your Lordship. In case of municipality areas or urban in nature, this distance criteria would not apply.
So these won't apply.
This won't apply. And in case of Gao Panchayat area, distance criteria will apply, Your Lordship. It's
Which one?
200 meters, Your Lordship, on the national highway.
Is this Gram Panchayat?
It's a Gao Panchayat, Your Lordship.
My challenge is on 3 grounds. First is
Yes. It is a Gram Panchayat.
It's a Gao Panchayat. Now.
How do you say? Anyway, the next one. And what is this about this mosque and all?
There's a rule for that, Your Lordship. How much distance should we take on a public place of worship, Your Lordship? At Rule 289 speaks of that, Your Lordship, of the excise rules, Your Lordship.
But why at the earlier instance, what was the report? On what basis did you give it earlier? Then, if it, the rule 289 was there, or did you have the license prior to that?
yes, Lord. In
Yes.
2014 it was issued. In 2017 it was shifted to the present site. There is a report. I annexed the report, page 25. Thereafter, in 2022, on license has been converted to off license. And at that time also there was an inquiry, and I have annexed the sketch map also. The map at page 32, which is the distance is to 220 meter. And earlier report says there is no. There is the
Where? Where
page,
is your
20
shop?
page 25 is the
Page 25.
Page 32. Is the
page
sketch
32 is the
map.
map, Lordship. Is the map.
Where-
220 meters.
Where is the mosque?
There is no mosque.
There is a mosque, they are saying.
They are saying
This is a
No.
public complaint
There is
inquiry.
a mosque as well as
as
Kali
well as
Mandir.
Kali Mandir.
two Kali Mandir
To Kali
and
Mandir.
one mosque. Where are no Kali Mandir?
Nothing
Is it
is
your
there.
specific stand
Yes.
that there is no Kali Mandir or mosque?
Yes.
Where is your statement in out here in the
Page paragraph 9 Lordship. Submitted there is no
there is
page
no
12.
there is no public place of worship within 150 meters of having a structure within covered area of more than 200 square feet. What is this square feet?
Huh?
There is a requirement
Yes,
that it
Lordship.
has to be have a 200 square feet.
Yes, Lordship is a definition under section 289(2). There is an explanation to public place of worship. What the purpose of this rule means: a place of public worship having a pakka structure with a covered area of more than 200 square feet, which is managed or owned by a registered public trust or a well-established and recognized management company.
And your distance is around 220 meters.
220 meters.
Why? Earlier they had come with some report.
Yes, Lordship.
Where is
Page
that?
Page
25.
25 is the report, Your Lord.
Page 20.
Five.
Recently, the government has decided to keep the IMFL to at least 200 feet. So you have shifted.
Yeah, I'm shipped.
Earlier you were within, but then you shifted.
And it is from the edge of the national
You
highway.
stayed it. Issue notice making it returnable by 5th of January 2024. Mr. R.R. Gogoi, it represents respondent number 1,
1,
2,
2, 4, and 6, your lordship.
4, and 6. Ms. Udas, the learned additional senior government advocate, represents the respondent number 3 and 5. 3 and 5?
Five.
3 and 5.
Executive engineer, your lordship.
Huh? 3 and 5? Or 3?
Five.
And Mr. P. Nair, your PWD represents
Five.
the respondent number 5. As the respondents are duly represented, extra copies of the writ petition be served upon them by 28 on or before 28/11/2023. 2023. This court have also heard on the interim prayer. It appears interim prayer for staying the operation of the impugned order dated 11/8/2023, which was signed on 3/9/2023 by the District Commissioner Hailakandi. This court, upon perusal of the materials on record, and more particularly the averments being made at paragraph number 9 of the writ petition, and also taking into account the inspection report which have been enclosed as annexure 5, annexure Roman 5 to the writ petition, is of the opinion that this is a fit case for stay of the impugned order dated 11/8/2023, which was signed 11/8/2023, which was signed by the District Commissioner Hailakandi on 3/9/2023, whereby there was a direction to the petitioner to shift her, to relocate or shift her licensed premises to a site which confer to another site, conforming to the excise rules and norms. Accordingly, the order dated, impugned order dated 11/8/2023, signed by the District Commissioner Hailakandi on 3/9/2023, bearing number EXC-13/23/2023, shall remain suspended till the disposal of the writ petition.
May one thing, your lordship.
Huh?
Pendency shall not be a power for a petitioner to approach the authority, and the authority will give him a hearing, a lot. Regarding, because he's
disposing
saying that no notice has been served to him. He was
Till the next day. Huh?
he said that no notice has been served to him. The pendency shall not be a bar for the authority to hear the petitioner, your lordship.
We'll see on 5th. I'm fixing it till in interim order till next day. On that day, we'll consider.
I have given it in paragraph number 13. That's 43, madam.
Paragraph number?
There are 9 work orders amounting to 7,52,370. All completed and completeness certificate have been given.
Who is to pay?
Work order is respond now 4 and 5. The
Executive. There are
No, the PHE is to pay.
PHE. It's a PHE.
And Mr. Naik, you are paying for finance?
Finance. Formal part.
To dispose of query. Disposed. 6 months.
very fine. your lordship.
Very fine pay.
Problem.
Mr. Naik, give your names, huh?
Problem.
R.R. Gogoi for you.
15.
Thank you, Lord.
Lordship, the petitioner was allotted with the work of constructing a maternity hospital in Mulaghat, 100% maternity hospital in Mulaghat in the year 2014. He completed the project, Lordship. Lordship, page 161,
158 lordship is the handing over certificate, annexure C, and page 161 is the completion certificate, lordship, page number 161. Lordship, after that, lordship, outstanding bill to the tune of rupees 4 crore 50 lakh is still it's yet to be cleared by the corresponding authority, lordship. Lordship, in fact, lordship, there has been a series of communication between
Which department?
lordship, the payments to be given by the NRHM, lordship. NRHM.
NRHM, who is it?
Not a P. Gogoi appear.
Hmm?
P. Gogoi appear.
Not there. You've seen him? Have you seen him?
Yes, Doctor, he is in the court. Lordship may not like to dispose of this matter today,
Why?
Lord, because this person, reputation of this person is not that good, Lord. He has some problem with the department, Lord.
Huh?
We have to initiate criminal proceeding against him. So let me have some instruction.
My humble submission, lordship, in this case, it's nothing related with other previous than opponent. Lordship, in this case, he has completed the project and is supposed to get his payment money. No,
Where is the completion certificate?
lordship, page number 161, lordship,
161.
page 161.
151?
61, 161. Oh, yes, completion certificate, lordship. Annexure D. May I read the one?
Did you complete within time?
Lordship, the project was delayed, lordship, because what has happened in this case is, lordship, the project, actual project site, it was changed and it was shifted to another location, it's 13 kilometers away from the original site. So, lordship, there was a delay, but it was completed, lordship, it is the allocated.
Where is the allocated extended time? What was the initial tender condition?
At page number, annexure A is my work order, lordship.
Annexure page?
Page 12, lordship.
Page?
Page 12, lordship, annexure A. I was allotted this project in the year 2014.
And what was the time?
22 months, lordship. But we could not complete it within
And where is
22
the
months.
extension granted?
Lordship, I have not next that.
How do I? Because there will be a question that whether you may have completed, but whether they have imposed liquidated damages.
No, lordship. In that case, lordship may kindly see annexure J, lordship, page number 170. For this, lordship, the PW department has made a balance work estimate, lordship, for the extra amount. Lordship, I am not claiming that amount, but for this delay,
This is for risk and cost.
extra cost, your lordship, page number 1, it starts from page number 170, annexure J.
Yeah.
Balance work estimate for construction of 100-bedded MCH wing. So an amount of 1 crore 52 lakhs 85,000 extra is needed.
It is not even sanctioned law. It was prepared by the executive engineer. But for sanctioning authority is the chief engineer.
No, he's not asking for that.
I'm not asking.
You didn't get any running bill.
Running bill, Lordship, at page number, I have got your honor, but outstanding amount is Lordship 4 crore 50. The project cost was 17 crores, 17 crores 50 lakhs. I have got the running bills, Lordship, but outstanding amount of 4 crore 50 lakhs is there. Lordship, may kindly see page number 162, annexure E, where the respondent number 4, there's a correspondence between the respondent number 4 and respondent number 3, where the respondent number 4 has given the reference of an amount of rupees 3 crores 11 lakhs, which is yet to be paid to the petitioner. Page 162, your honor. This is the communication from respondent number 4 to respondent number 3.
Yes, Mr. Naik, what are you saying about criminal what?
Lordship, in some other cases, Lordship, we even have the reputation of submitting fake bank guarantee. So I would like to go after this matter. This
Big
person.
penguin. Then, are you using the premises or not?
No, this was this tender work was issued prior to that, not that incident.
Understood. That is a different aspect.
Yes.
But how does this has any relevance with this?
I'm just praying for some time, Lord, to go to the actual fact, Lord. What is the exact amount due to me?
You notice making it returnable on 5th of January 2024. Union of India,
Not
Mr. A.R. Kapildar.
on behalf of RD.
No.
Yeah, yeah,
Represents the respondent number 1. Mr. P. Nayak appears on behalf of the respondent number 4. However, none have chosen to appear for the Health and Family Welfare Department of the Government of Assam, as well as for the Mission Director NRHM, where the matter has been called. The learned counsel appearing on behalf of the petitioner submits that there is a standing counsel for the Health and Family Welfare Department, as well as also for the mission for the NRHM. Taking into account the above, this court directs the petitioner to serve extra copies of the writ petition to Mr. A.R. Kapildar as well as Mr. P. Nayak, who represents the respondent number 1 and 4. As regards the respondent number 2 and 3, the petitioner is also given the liberty to serve extra copies of the writ petition upon the respondent number upon the standing counsel of the Health and Family Welfare Department of the Government of Assam, as well as the NRHM. The case of the petitioner herein is that on 17/11/2014, the petitioner was issued a work order for construction of a 100-bedded MCH wing with quarters at KKTH in Golaghat under NRHM by the Chief Engineer PWD Building. Pursuant thereto, an agreement was entered into by and between the petitioner and the Chief Engineer PWD Building. The case of the petitioner is that the said work was duly completed. On 23/6/2022, and the construction and the constructed work and was completed on and was handed over to the respondent authorities. This aspect could be seen from a perusal of Annexure C and Annexure D to the writ petition. It is also seen that the period of the no defect liability has also expired, as was certified by the executive engineer PW bracket BNH bracket D, Golaghat District Territorial Building Division. The record further reveals that the petitioner have been representing before the respondent authorities for an amount of rupees
4 crore,
how much?
4 crores 50 lakh, 4 crores 50 lakhs 54,563.
4 crores 50 lakhs 54,563, and had also issued a notice to the Mission Director, National Health Mission on 30/9/2023 for payment of the said amount. However, as the said amount has not been paid, the instant writ petition has been filed. Mr. P. Nayak, the learned counsel appearing on behalf of the respondent number 4, submits that he would like to take instructions as regards the completion of the work by the petitioner and as to what amount the petitioner would be entitled to. On the next date, the respondent number 4 is directed to file their affidavit without fail by 3rd of January 2024, clarifying as to the entitlement of the petitioner. The respondent number 3
Lordship, if possible, in case of the Council for Health and Family as well as National Health Mission, Can Vigo's name be recorded?
Not appearing. I'll help
Lordship,
it.
he's on legs in court number 2, that's why.
Let him file an appeal and go to court number 2.
For admission, item 16 and
Actually admitted down, but deputy said, my lord, that they will put some joint instruction. But in fact, my lord, the work is completed long back and they are enjoying the field. If you also see the first affidavit filed by the,
What are you claiming here?
my lord, if your lordship see the page 10 of the affidavit filed by the collaborator. My lord, this is the amount, my lord. 2 cases, my lord.
What is your case?
My case is, my lord, the 2 works are allotted to us. Not a single running bill has been paid to me, my lord.
Is the work completed?
No, I could not complete the work because not single running bill has been paid. Then, my lord, they got the work completed for some other contract. But my running bill, my lord, I have done 53% and 55% work. So this amount is, my lord, admitted. My lord, they have said that 53-55% has been done. And
Yeah.
now they've completed. I have filed the additional affidavit showing the photographs, my lord, that they are enjoying the, my lord.
And what is the other matter?
I'd say, my lord, 2 matters are almost same, my lord. One is for construction of this public auditorium, other is marketing sale. In both cases, same,
One
my lord.
is?
Well,
One is for
marketing sale,
marketing sale and the other is
public auditorium.
public auditorium.
Both are completed, both are, my lord, running. my lord.
Now, these works have been given to somebody else.
This work, my lord, was done by some other contract. But my bills are pending, my lord. Not a single running bill has been paid. Yeah. And if your lordship see, my lord, page 10 of the affidavit in opposition, my lord. That is the
What do they say?
page 10 and 11. The first case, my lord, is 93 lakhs and what? And second one is, my lord, so far marketing side is 90. And page 11, my lord, they have given the percentage also, what I have.
As per the contract, were you entitled to the running bill?
Yes, sir. Well, they have to.
And they duly submit out here that they would make the payment
Yes,
upon
from time to
receipt.
time, my lord, they have to make the payment. Otherwise, how a contractor can, my lord? That's the,
And what is the other affidavit?
no, this is the additional affidavit filed by me, my lord, that I'm showing the photographs, my lord. Page 62 onwards, my lord. If you'll also see, this is the, my lord, the completed building, 62, 63, and 64.
Yes.
Shops are also there.
We've specifically mentioned in para 9
I've seen it.
and also the document matter, Annexure C.
No, you have categorically admitted that you will make the payment upon receiving the funds.
Yes.
But can this go on for all time?
No.
You pay 6 months. Why should I look into all other things? You can't have it.
I
Or
agree
give
with
it
my-
on rent, whatever he has constructed. He will use it on lease. Give it to other people. What did you construct? Public auditorium.
One
No,
public
he,
auditorium,
he can use it as a marriage hall. Huh? Give it. PPP. Public, private, public partnership. What do you say? That is the best way.
That decision I'll have to.
And the other is market share.
Marketing.
He will give a market and give the permission also.
Matter I'll need to.
Cattle market.
Then what the resolution number 2 at page,
And you can't say that when I have money, I will pay. Did you say, was that the term of the contract?
this was a condition that was laid on before the issuance of the preliminary work order as well as signing of.
No,
the
no, in
agreement.
your tender notice.
My lord, we will kindly see the paragraph prior to that, my lord. My lord will read that at page 8. It says
Page
page 8, my lord,
of
affidavit.
of our affidavit notice. He was well aware of what the condition was, and thereafter he signed the agreement
Yes, where?
at the first para at page 8.
Yeah.
The tender committee recommended for issue of preliminary work
No,
order.
no. This is in which matter? WPC number?
This is 3413, madam.
341. Yeah. Where is it? Page 8. Yes.
The tender committee recommended for issue of preliminary work order and signing of agreement at an early date by depositing the earnest money of 2% by way of bank draft, bank guarantee or TDR to be treated as performance securities and remaining 8% fully deducted from the bill. That is part of the resolution number 1, madam. And in the resolution number 2, it says that decided to issue work order to the lowest bidder.
No. I'm not on those. I'm asking you whether in your tender condition, it was a mandate that he will work, but we will not pay. We will only pay when we get funds. Because when a person comes out here to work, he would obviously be. How is the payment condition? You can even impose compensation for delay. No payment shall be made for work estimated
In para eight
for-
also
to
we state,
cost
madam,
less
that it
than
was
rupees
mentioned in the work order.
24. Yeah. The contractor shall, on submitting the bill, therefore be entitled to receive a monthly payment
Yes.
for proportion proportionate to the part thereon approval and passed by whose certificate of such approval and passing of the sum so payable shall be formal and conclusive engagement. But all such intermediate payments shall be regarded as payment by way of advance against the final payment only, and not as payment for work done, actually done and completed, and shall not preclude repairing of bad work to an imperative to an. Well, can you keep on saying that, oh, we'll get funds? Then why do you at all do work? You want an auditorium to show it to the public, but you don't have the money. Or the money must have been sent to some other place. Isn't
I don't
the
think
market said the money must have gone for payment of some taxes. Something must have happened. Can't have happened like this.
This was not a person to government administrative approval and financial sanction accorded to the government.
Approximate tender, bid security, cost of the bid
Money couldn't
document.
have gone elsewhere.
Huh?
If you read resolution 1, at the beginning it says that regarding tender process for construction of new market shed at Kawai Mari and construction of public auditorium at Ambagan within an estimated amount of rupees 180 lakh each, wide government administrative approval and financial sanction. So this money couldn't have gone elsewhere.
Money was there. Money must have been used in some other place. When you have the sanction, obviously how, but then why the petitioner was not paid?
Probably one of the money. is
Now
not
the
used.
next question is, why shouldn't this court impose interest upon it? As per the Interest Act, 1970.
Bank there. It's not a bank there.
You only make calculation as to what will be the interest. Nothing more than that. Payment is to make, but in
My lord, in pass an order has stated right at the beginning to give a time limit within which I think this money is to be.
recording, time limit. What do you want?
Others, my lord, may give me a short date.
No short date. This matter I've been seeing every time it is coming. Why? And why what is the question of joint inspection, looking into all these things? Is this court sitting on there? This court has no business out there to look into as to how much work he has done on. The only thing, if it is an admitted fact that he has done this amount, he has to get it. That's all. And you have admitted, yes, we are to pay him. but we are not in a position to pay in view of non-availability of the funds. Then I would have understood that he didn't work. There might be a case of he has left the work. Then those are questions of fact which will go to the civil court for decision. But that is not your case. We have already made everything, but the fact that we are not in a position to pay, that's your case. Any further delay would not be in the interest of justice. Or would you like to stack your office with more files? Yeah. Send this disposed of file to your client. Yes. Both the repetitions are taken up to the instant repetition 341/2007 has been filed by the petitioner. Claiming an amount of rupees 97,23,640 along with interest at the rate of 18% from the date of submission of the running account bill in respect of the work order by letter bearing number NZP.1353/Roman 1/2014-15/3627 dated 26/3/2015 for the work namely construction of marketing shed at Kawaimari under Lokwa Development Block. The facts, as could be discerned from the petition, is that the petitioner is that on 15 that in a newspaper in the Assam Tribune newspaper dated 15/3/2015, a notice inviting tender was issued by the respondent number 5 on behalf of the respondent number 3, inviting tenders from experienced and reputed contractors for the work for various works, including the construction of, this is auditorium, na? No. Construction of a marketing shed at Kawaimari under Lokwa Development Block. From a perusal of the said tender notice, it reveals that the approximate tender value was rupees 174,72,339, including electrical work of rupees 18.72 lakhs. It was further mentioned that the time for completion was 9 months. The petitioner participated in the said tender process and along with other bidders, and the petitioner was found eligible for being awarded the work for which a letter of intent was issued intimating the award of the work in favor of the petitioner, and the petitioner was further asked to deposit the performance security. Accordingly, the petitioner deposited 2% performance security on such deposit, and the petitioner thereupon was issued a formal work order by letter bearing number NZP.1353/PT-Roman 1/2014-15/3627 dated 26/3/2015, issued by the Chief Executive Officer, Nagaon Jilla Parishad. It is the case of the petitioner that as the period of the completion was within the period of completion was 9 months, the petitioner immediately upon receipt of the work order dated 26/3/2015 took steps for mobilizing its men and machinery so that the work could be completed within the period stipulated. It is the further case of the petitioner that though the petitioner took appropriate steps for completion of the work, but the respondent authorities failed to discharge their part of the obligation for which the petitioner could not commence the work, inasmuch as the respondents failed to furnish the site, drawings and designs, etc. It is under such circumstances that the petitioner had written communications to the respondent number 3 and 4, which have been enclosed to the writ petition as annexure Roman 4 and Roman 5. It is further alleged in the writ petition that approximately after 4 months from the date of issuance of the work order, on 27/2015, the site was handed over to the petitioner for commencement of the work. However, the petitioner could not commence the work due to the existence of a boundary wall which was to be demolished, and permission for such demolishment was accorded by the principal primary HS school only on 6/8/2015. Thereupon, the petitioner commenced the work for the first gallery of the work in question, and upon achieving the desired progress, the petitioner, by letter dated 27/10/2015, requested the respondent number 4 to hand over the site for the second gallery of the work in question, so as to enable the petitioner to continue the work together in all fronts and complete the same within the stipulated completion time. It has been further alleged that there has been certain delay thereafter, that the respondents thereafter also failed to hand over the site for the second site, hand over the second site, the site for the second gallery. It is the further case of the petitioner that the petitioners have also, as per the terms of the agreement, as per the general rules and directions for guidance of as per the terms, as per Form 2 of the item rate tender and contract work, general rules and directions for the guidance of the contractor, which was made a part of the agreement, applied for payment of the running bills. However, the running bills were not paid, for which the petitioner could not further proceed with the work. It is the further submission of the learned counsel it's further seen from a perusal of the writ petition that the petitioner claims that an amount of rupees 97,23,640 was payable to the petitioner on account of the running bills. The petitioner thereupon have represented before the respondent authorities time and again for release of the running bills. However, the same have not been released. It is under such circumstances that the petitioner has approached this court by filing the instant writ petition seeking the said amount to which the petitioner is entitled to, claims to be entitled to, along with interest at the rate of 18% per annum. The record reveals that this court, by an order dated 7/6/2017, have issued notice. The record further reveals that the respondent number 4 had filed an affidavit in opposition. In the said affidavit in opposition, it was mentioned that the tender value for the work, namely the construction of the market shed at Kawaimari under Lokwa Development Block, was notified as rupees 1,74,72,339, but later on the value was fixed at 1,73,84,977 as per the plan and estimate prepared for the work as per the schedule of rate of the CPWD building for the year 2013-14 under the APWD building Assam. It was mentioned that the scheme was partially changed and renamed as construction of market shed and sports gallery at Kawaimara, and as per the demand of local public, and accordingly the plan and estimate was prepared. It is further seen from the affidavit filed by the respondent number 4 that the awarding of the contract to the petitioner was not, there was no fault in awarding of the contract to the petitioner. It is also admitted in the paragraph number 6 of the affidavit that at the time of taking up the scheme, the work site was not in a condition for execution of the scheme due to existing concrete wall and other natural problems. It was also admitted that to overcome the said difficulties, it took time, and therefore handing over of the work site was delayed, and the same was unintentional. It was also mentioned that the work site was handed over to the petitioner by certificate dated 27/2015. Further to that, it is mentioned that in the work order issued to the petitioner, it was mentioned that necessary payment would be made subject to receiving of funds from the government. The government had processed regarding supplementary demand proposals by letter dated 1/12/2015. It was also mentioned that the running bill submitted by the petitioner was submitted to the Commissioner of Panchayat and Rural Development, Assam, dated 16/3/2016, with a request to release the fund so as to enable for payment to the writ petitioner. But no fund has been received as the matter is under process. At paragraph number 10 of the said affidavit, it was categorically mentioned that communications have been made with the higher authorities for release of the fund, and the same is still pending for disposal. However, further, it is stated that after receiving the funds, payment could be made to the petitioner. From a perusal of the said affidavit, however, it reveals that there is no denial in any manner as regards the entitlement of the petitioner. as regards to the amount claimed by the petitioner.
Page 36 of the date. Page 36 of the date on the data is there.
Page
36.
36. This court, however, also finds it relevant at this stage to take note of the communication dated 16/3/2016, which have been referred to in the affidavit filed by the respondent number 4. And which is the part of annexure Roman part of the writ petition and enclosed as annexure Roman 13. From the said communication, it reveals that it reveals that the Chief Executive Officer of the Nagaon Jilla Parishad submitted the running bill in original of an amount of rupees 93,32,551 against the public auditorium at Ambagang and rupees 97,23,640 against the marketing shed at Kawaimari, both under Lakwa Development Block for favor of information and necessary action. Along with the said communication, the status report of the physical achievement along with photographs were also sent. It was also mentioned that the commissioner, it was also requested by the said communication that the payment be released at an early date for early completion of the scheme. The above materials on record, this court have duly heard the learned counsels for the parties. The above material, in spite of this, next bit. This court also finds it relevant at this stage that the instant writ petition has been pending for the last 6 years. 6 years. But till date, the respondent Panchayat and Rural Development Department have not chosen to file any reply. This court had duly heard the learned counsels appearing on behalf of the parties. From the materials on record, it transpired that the petitioner claims an amount of rupees 97 lakhs.
93.
97 here. In this case, it is 97. No? Claims an amount of rupees 97 lakhs 23,640. And the respondent number 4 duly admits the same, as could be seen from the affidavit filed by the respondent number 4, as well as also the communication dated 16/3/2016. The Department of Panchayat and Rural Development have also not denied the said aspect of the matter. Under such circumstances, it is the opinion of this court that if the petitioner is entitled to the said amount of rupees 97 lakhs 23,640, the said amount should be paid to the petitioner. Non-availability of the fund cannot be a ground to deny the petitioner of his legitimate entitlement. Be that as it may, as there are certain, as the What is this measurement books and all? Don't you have measurement books?
They have measured, my lord, their percentage they have given,
Maybe you never know what happened. Yes.
they ought to be, my lord.
Be that as it may, this court finds it relevant. This court is of the opinion that a final opportunity should be given to the Panchayat and Rural Development Department to make a further verification as regards the entitlement. Accordingly, this court therefore directs the Secretary to the Government of Assam, Panchayat and Rural Development Department, either by himself or through his delegate, to make necessary verifications as regards the actual entitlement of the petitioner. If upon verification so carried out, it is found that the petitioner is entitled to the amount so claimed or any part thereof, the said amount be released to the petitioner. Full stop. In this regard, this court further directs the respondent number 3 and 4 to provide necessary assistance for the purpose of releasing of the said for the purpose of carrying out the said verification. Full stop. The respondent authorities, the Secretary to the Government of Assam, Panchayat and Rural Development Department is further directed to also is also given the liberty. The Secretary to the Government of Assam, Panchayat and Rural Development Department may also seek for necessary clarifications for the petitioner if so necessary. However, taking it into account, next level, this court further of the opinion that as the matter has been pending from the year 2016, that the entitlement of the pending from the year 2016, these directions so passed herein above should be complied by the Secretary to the Government of Assam, Panchayat and Rural Development Department within a period of 4 months. He is not the Panchayat Secretary. You are the council.
I'll leave it to my court for a reasonable time, maybe.
4 months. This is 2016.
And-
2023, we are giving 6 months.
That is why I'm not.
Within a period of 4 months from the date, a certified copy of the instant order is submitted, is served upon the Secretary to the Government of Assam, Panchayat and Rural Development Department. Try again. Same 16 everything. Auditor. That is the marketing. Notice Second, same. I'm only asking him the change from marketing set to public auditorium. Amount will be earlier was 97, here will be 93. Yes, what do you want?
I'll keep the name. Names of appearance.
Give you. Thank you, Devnath. Yeah. Yes, Mr. Tell me.
My lord, last order that is 25-1.
Oh, this matter.
Yes, my lord.
Oh, why did the one mention for by order?
It is instance of the, my lord, the other side, the matter has been.
Huh?
At the instance of the other side, matter has been listed.
This committee, the learned junior governor shall obtain insight as to whether the master plan of Tezpur has been approved and adopted by the state of government or not. And yes, what is it? The revised master plan has been notified on 2010. So it has been 2010.
No, my lord, this is regarding the That is a publication. After that, that to be approved by the government. So that part is that man.
No, that is it. It has been mentioned as
Yes, there's
has
notification
been
mentioned.
notified by the government notification dated.
Same notification is mentioned. Order, kindly go through my order. Same notification.
In exercise the.
There's a two part, man. The master plan is notified, but they have to be approved by the government. That part is lapsed. That's part the act also. The order also that the notification is reflected. Number of the notice.
Yes, my lord, that approval part I need some.
We are asking, and this is going on for long. This matter came up before this court in 2022, and this court had passed an order. Where is that order?
Actually, well, a lot of constructions and the other thing, even the deployment
After
authority has now-
hearing the matter, it could be seen that the examination in respect of the master plan has notified the journal, if any, as the development, if any, would be required further, would be further required for the purpose of adjudication. So I've asked you to place that. Now the question is, the instruction which have been sought for is as to whether it has been approved.
Sure.
And you are not getting that. What is this? These people, they don't understand. Who is this? Joint Secretary to the government of Assam, they don't understand
1 week.
English. Difference between notified and master
Yes.
plan and approved. Because the order makes it very clear.
Yes, I have.
Has been approved, and Mr. Goswami, the learned, has obtained instruction as to whether so and so. Here it says, presenting the so and so demand, a notification of the demand has been issued in respect to the final. So there is no question of not notified. It has been issued by the government, but whether it has been approved. Because if I remember, this
Yes.
notification mentioned it will be. Where is
Yes.
that notification actually? I've seen it somewhere.
Earlier, well, that notification was not cancelled, but simply they are saying that
Hmm?
later on, my lord, they have produced that notification. In my pleading, my lord, that was at the time of pleading,
Hmm.
the specific notification number was not there. Only they are saying that their notification on my pleadings to reply. But they subsequently, after a lot of my lord, deliberation, then that they have produced this notification regarding the publication of the master plan. But it is not approved or disapproved, it is not. So our case is that unless and until it is approved, that cannot be finalized on the basis that they cannot go. And my lord, most interestingly, but I have subsequently, my lord,
This court, by an order dated 25/1/2023. Oh, this is before almost 1 year.
yes, my lord, January.
1 week ago.
Had directed the learned junior government advocate to obtain instruction as to whether the master plan for Tezpur have been approved and adopted by the state government or not, and if approved, on which date. The relevant notification publishing the approved master plan, if any, was also directed to be
Yes.
produced on the next date. Today, Ms. M. Bormon, the junior government advocate, places before this court an instruction issued by the Joint Secretary to the Government of Assam Department of Housing and Urban Affairs, whereby wherein it has been mentioned that the revised master plan for Tezpur was notified by the government notification number UDD bracket T oblique T 125/06/102 dated 24/8/2010. In that regard, an instruction issued by the Director, Town and Country Planning Assam was also enclosed, wherein also it mentions the same. This court, however, had sought for the instruction as to when the said master plan was approved and adopted by the state government, in as much as notifying the master plan would be different from approval and adoption by the state government, as it is the contention of Mr. P. Mohanto. This court further finds it also relevant that during the course of the hearing, only the first page of the Assam Gazette, dated of the Assam Gazette,
Schedule is
relating to the notification dated 24/8/2010 have been produced,
schedule is in the next,
and not the entire one, huh?
schedule is on the next page.
That schedule.
Schedule.
No, you have to produce the entire one. What is this half-hearted business?
It's related to test code only that part.
No, you have to produce notice.
Map and everything they have put it. Including map also.
No, map tab I don't want. But the thing is, we only want this notification. Now, once this notification is not full, what is this
Yes.
part-wise? The government is not paying. The government advocates.
Oh my God.
No stationery is being paid.
Page that it-
Now, what is this? The
But
first
it-
part, does it end one and
that
two
is
only?
right.
Does it have
I-
three? Where's the signature of whose person who has notified?
That is not. it.
Yeah.
I-
It can't be. Taking into account the above, this court fixes the matter again on 18th of December 2023. On the said date, Ms. M. Borman shall apprise this court as to whether the notification issued on 24/8/2010 would constitute the approval and adoption by the state government, and also produce the master plan, the said notification in the entirety, insofar it applies to Tejpur. Tejpur, na?
Yes.
Tejpur. The instructions so placed there by Ms. M. Borman is kept on record and marked with the letter. Get your instructions.
Master
19.
My lord,
Yes,
status
what
report
happened
was
is
called
these
for,
two
my lord.
dates.
Status report was called for. Yeah.
Mr. Bhuya, you are Zakir Hussain.
My lord, I am Zakir.
The case is pending out here because of
This could be.
to obtain your specimen signature.
They have not come on me or call me. They have not asked me to.
That's good. You want the investigation to
Yes,
culminate.
Yes, my lord.
We do one thing. You go there,
Yes, yes.
provide your first pay area. And
Fine.
there's the phone number of Rishikesh Gorman, who is there now. The case is pending.
Fine.
And it is there. You give a photocopy, madam. You have it.
I'll get.
Give a. We keep the matter pending. because this, you will require this. And by the way, have you received the copy of the award?
My
No.
lord, I have, after the last order, my lord, I have inquired to the client, he has not received any order. Okay.
So if it is not received,
My lord.
then no action can be taken
Yes,
against.
yes,
Have you served him the copy of the award or not?
The arbitrator must have, my lord.
No,
But
no.
uh,
You asked because you are the person who has the conciliator.
no,
You-
and I was the conciliator because asking for that's
Whatever may be, you must be knowing it. Why didn't you forward him the copy of the award?
yes, my lord. I'll tell.
If you don't do it, have you seen section
Yes, yes,
31(7)?
Yes, earlier is section 31(3) was there. Now
Thir-
is 31(7).
31(7) read with 32.
Yeah.
And there are many judgments. In fact, I have also delivered one judgment
Right.
as to when it culminates.
Yes,
It only culminates upon delivery of the award.
the receipt
And the
of-
delivery has to be made in terms of section 343.
receipt of the award is to be.
So that has to be given. Because
Yes.
unless you don't, you can't act on that.
Yes.
And they can't enforce. Here, they have to enforce through the court.
Yes, sir.
So if they have to enforce to the court, you can very well move an execution application.
My lord, before enforcing, they want to conciliate, my lord. That cannot be done at this time.
That is okay. But anyway,
Hmm.
conciliation can't happen. Conciliation is over.
Fine.
But we are only here limited. We can't go for this arbitration or
Fine.
anything. Huh? Only thing which is limited out here is for further proceeding against, because the award has been passed, so nothing remains.
Fine.
So as regards this, we keep it. You give your signature out.
Yeah.
Pursuant to the order dated 17/11/2023, passed by this court, the officer in charge of the Dispur police station had submitted an instruction status report to Ms. Udas, the additional senior government advocate, wherein it has been mentioned that pursuant to the FIR so filed by the petitioner, investigation was carried out by the investigating officer. It was also found upon investigation that one Shahrukh Aziz, SHARUK, Aziz, made the forced signature and made the forced agreement of Zakir Hussain, the petitioner, as guarantor. The said Shahrukh Aziz was arrested on 23/6/2015 and forwarded to the court for judicial custody. Subsequently, the main accused, Antanu Basumotari, got anticipatory bail from this court in AB number 2441/2018. It has also been mentioned that the case remains pending for obtaining specimen signature of Zakir Hussain and to send the same with documents to the FSL for verification. The copy of the said instructions to place is kept on record and marked with the letter X. Mr. A.R. Bhuya, the learned counsel appearing on behalf of the petitioner, submits that he would instruct his client accordingly to do the needful in view of the said instructions. List the matter again on 5th of February 2024 for an update as regards the said dispute PS case number 1187 of 2015.
Obliged.
20. Please, Your Lordship. This is regarding Millard eviction matter.
Huh?
The petitioners Millard their shops and their establishments were Millard demolished by the Millard Circle Officer of Lahore. And they
That
have
day I was supposed to dismiss, na? Who is Zedamit?
and their
Because of you, I did not. Anyway, tell me.
my lord, Lordship will kindly have a look at Millard affidavit in opposition Millard submitted by the concerned circle officer. Page 2 and page 3. Millard. There are 4 and there are 5. Millard. Some false settlements have been made.
Yes, what is the affidavit in opposition?
This was submitted by the concerned circle officer, my lord. They said in para 4 that lands from which,
Wait.
page number 2, my lord, of affidavit in opposition.
I'll better respond number 4.
As per number
What
4,
does he say?
as per number 4 said in para 4 that, my lord, land from which the
The
petitioner
deponent states that the land from which the petitioners were
Evicted
evicted is not
not
purely
purely Patta
Patta
land.
land. The
the
land is purely roadside government.
government, my lord. And in the next paragraph, my lord, you will find at page 3, my lord, second line, my lord. Page 3, my lord, in the second line. Tag number has been mentioned as 47, my lord. And the annexure, my lord, that I have submitted, my lord, before your lordship, my lord, annexure 1, my lord. My tag number, my lord, at page 14 of the petition, my lord. It shows, my lord, something else, my lord.
Annexure?
Annexure 1, my lord. The tag number of some of the petitioners are, my lord, tag number 75 and 76, 74 and 75, under same, my lord, area, same case of.
No, where is your notice?
Notice was not never served upon me.
Then here you have been thrown out.
No, my lord, the shops were demolished, my lord. And lordship will kindly have a look at page.
So you are, no, there is notice for eviction.
Nothing, my lord.
Annexure 7, page 32 of your petition.
Yes, that notice was never served upon us. He is someone else. Why I have annexed this, my lord, notice, my lord, just to show that, my lord, this notice was served upon someone else by the concerned deputy commissioner without mentioning the date, my lord. No date was mentioned.
It's okay, but here the tag number is 48.
The tag number is 74 and 75.
No, here it is mentioned
Here
48
it is mentioned as 48
in the
7.
notice. No,
Yeah.
in the notice it is mentioned 48.
Yeah.
Where are you getting?
In the notice, my lord, they have submitted an
Huh?
affidavit in opposition, my lord, para
No,
5, my lord.
no, where are you getting the schedule?
Schedule is from, my lord, annexure 1 of my execution, my lord, page.
Kindly come to page 32.
Yes, my lord. Yes, my lord. Page 32 is a notice, my lord, which was issued upon someone else, not the petitioner, one of the.
What is the schedule at page 32, which is not there in the main one?
I'm very sorry, it was wrongly typed.
What?
It was wrongly typed.
Why?
Very sorry.
Now, what do you want?
Is the typographical mistake.
It's okay. Condoned. Now tell me, what do you want?
My lord,
You have been thrown out.
the shops were demolished.
You have been thrown out from your Patta land. That's all.
Yes.
You are the owner of which land?
The land annexure 1, my lord, page
What is the owner? How many petitioners?
6 petitioner,
That is the problem.
Yes.
Everybody coming out here together, that makes the
7
difference.
petition.
Yeah. Have you enclosed their deeds on which they claim?
My lord, the sale deed of 3 petitioners are there, page 14.
Why not the others?
My lord, that I could not obtain, my lord, during.
Then how do you mention do?
My lord,
Page
as per-
5?
As per this, my lord, this annexure 1, the sale deed regarding the petition number 1, 2, and 3, my lord. Tag number shows that 74 and 75 of the same, my lord, Kisamat, same area. But as per the affidavit in opposition submitted by the circle officer, my lord,
No,
tag
circular
number-
officer makes it clear that we are not doing anything as regards the other. We are only as regards tag number 47.
47.
So tag number 47 is a government land and there we are doing it.
Yes.
Now the fact that your basic contention out here is no, it is not tag number 47. They have in fact went into our land.
My, yes, sir.
So how does this court ascertain that aspect?
There is a difficulty, my lord, in there. My lord,
Because your entire basis of the case is different.
yes, sir.
You are saying that pay compensation. You are saying that
My lord, because, my lord, in,
that is your prayer.
yes, that is my
Your
plan.
prayer is
Because my lord,
look
the
here.
provisions were never.
See these provisions of the Act of 2013, and as such, payment of compensation should be there. The petitioner should be rehabilitated and whatnot. But the main aspect is now which comes into that they have thrown you out
Right.
from your land,
Right.
but they say that it is tag number 47.
Right.
Now, what is your next course of action you should do? Enlighten this court.
Well, they should file their affidavit in acquisition. in
They have
appropriate
already
manner.
filed.
They have not filed in any appropriate manner. my lord, in the, my lord, para number, my lord, 5, my lord, if your lordship kindly have a look at the last, my lord, 6 lines, my lord. They were also informed by LM, that is Lord Mondo, and by Gaupur. These are some of the false government. They were supposed to issue, my lord, notice upon all the persons whose lands have been, my lord, enclosed or taken away by the government.
Is it required? If it is
Notice
government
is
land,
required to be served.
if it is government land,
If it is, my lord, mere Pata land.
Pata land definitely.
Yes,
So
my lord.
therefore,
Now we
what,
are claiming, my lord.
therefore, Mr. Counsel, what is your course of action to do? What should you do?
Lord, a fresh inquiry may kindly be initiated.
Huh?
A fresh inquiry may kindly be initiated. The land and the demolition is carried out in our place, whether those land belong to the government land.
Have
or
you
Pata.
filed a reply to the affidavit in opposition where they say it is 47?
I'll file, my lord.
Why you have
Kindly allow
not
me, my lord,
filed?
2 weeks time. 2 weeks time.
But you have already been thrown out.
Shops are demolished.
So filing a reply would it help you? What
Lordship
do you
will
need
decide, my
for early disposal of
If I-
the matter
if I
so
find
that you can give relief to your client? What
lord.
will-
Positively, I'll file within 2 weeks.
Huh?
I'll file, my lord, my reply within 2 weeks, my lord. If your lordship allows it. This will help us.
You don't want to help yourself. Why should this food boil when?
Take care of.
The Learned Counsel appearing on behalf of the petitioner submits that although in the affidavit in opposition it has been mentioned that the petitioner mentioned that the eviction was carried out in respect of government Act number 47. But in actuality, the petitioners have been evicted from their Miyadi Patta land. Be that as it may, there has been no denial to the fact stated in the petition, in the affidavit in opposition, for which the petitioner seeks for a liberty for filing a reply. It's the matter of the 4 weeks.
Lordship will kindly fix the date.
Why? You have failed.
By
The best order would have been
my lord.
this court directing
By
the respondent authorities to verify as to whether this land has been actually 48, 47 or merely Pattana. And if it is merely to initiate process for acquisition, and if not, then nothing is there. But you want to delay.
My lord. Thank you.
I have in the additional affidavit, I have quoted.
You have quoted it, I've seen
Yes,
it at
yes,
page
in the
31.
additional affidavit.
Yeah.
There are 3, your lord.
Come into collect.
Para 79, your lordship, section 79, your lordship will find, your lordship. The annual value of holding shall be determined in accordance with the procedure described below in section 79A, 79B, 79, 79B, 79E respectively. In the said section, unless there is any of the thing, anything repugnant to the subject or context, the following terms shall be at the meeting respectively assigned thereon.
Yes.
Annual rental value means the rent that holding is capable of fetching over a period of 1 year. 2, publish means publish in one vernacular and in one English daily newspaper, predominantly in circulation in the notified area of the municipality. Then commercial holding, then industrial holding, then 79A, your lordship. 2, regarding situation of holding, the following matters shall be considered. Holding on the principal main road, holding on the main road, holding on other clauses above. Regarding use of holding, then this, your lordship. 5 is important, your lordship. Subject to the approval of the following committee, a municipality may from time to time publish the list of principal main roads and main roads if necessary, modified in the list as may be decided by the committee. Now, my case is that this procedure has not been followed. Publish, your lordship, as defined in section 79(2). It should be published in vernacular and English daily newspaper, your lord. That has not been done.
in the instant case.
Now, what are you challenging?
I have, your lordship, we have got a copy of, your lordship, the entire list of, your lordship, taxation, your lordship, that has been fixed. Otherwise, they have not, your lordship, notified in,
Ah,
they have not notified it in anything, anywhere, your lordship, but we have collected from the office, your lordship. And your lordship, this is the list, Annexer D, page 21. We have put to challenge, and the, here, your lordship.
why are you putting this to challenge?
Because, your lordship, this is the, your lordship, list issued, your lordship. In fact, this is the list pursuant to the tax, your lordship. No other notice has been issued. This is the only list they have issued, your lordship. And
Yeah. Then,
And we
if
have-
this notice has been issued, then how does it affect you?
because, your lordship, our names are also there, your lordship.
So,
I will show that.
so have they demanded any amount from you?
Yes, this is your lord.
Have they demanded any
Yes,
amount?
your lordship. Now we are being asked.
Where is the
to pay.
notice? Where is
That
the notice?
notice is not there. The people have come, your lordship, and asked us to pay, your. That's the problem, your lord. They have
Are
neither.
you saying that the people are just
People are-
asking you to
yes,
pay
dear Lord.
without even a
No,
notice?
notice has not been issued till date, your lord.
Isn't it required?
Your lordship, that, your lordship, specifically, it is not.
How is it, how imposition will be made?
Normally, your lordship, municipalities does not issue any notice, your lordship. Citizens regularly pay the tax, your lordship.
Have they published this?
Your lordship,
No, no, Mr. Bothakur, have they published?
it was, your
Yes.
lordship, from the office, we get a copy. But otherwise, there is no public.
So if there is no publication, then because if you see 79F,
Lord,
the rate of taxes determined in accordance with the provisions of this act shall be published by the respective municipal board of the town committee by issuing a public notice
Lord.
within a period of 3 months from the date of coming into force of the suit. This determination shall be valid for a period of 5 years. At the expiration of every 5 years,
Lord.
new determination of rates shall be taken and shall be published in the same manner. Now, has that been published?
No, they have not published.
So then, if they have not published, why you are putting the ball before putting the cart before the horses? If they have not done till now,
Lordship. Lordship, no, but your lordship, they are insisting on paying, your lordship. That's the problem.
they're insisting on
Paying,
paying.
your lordship, tax.
How?
No, normally, your lordship, municipalities, your lordship, do not issue notices. That's the problem, your lordship. Even in Guwahati also, your lordship, no such notices we receive, your lordship. Even after non-payment of, your lordship, property tax for quite.
And nowadays, so it comes in your mobile only, Guwahati.
Lord.
You have to pay this.
Lord.
Okay?
Lord. No, that has not been happened in respect of art. That's the problem.
Okay, we should notice.
Lord.
And in the meantime, we make it clear that without taking recourse to 79F, there shall not be any imposition.
Lord, that
Without taking, and if it has been taken, it is okay.
Their main grievance against the municipal board, response number 4 and 5.
Huh?
Their main grievance is against the response number 4 and 5.
Hmm.
The municipal board.
No, it's okay.
What?
But the fact is, you can't do so without following 79F. 79F categorically mentioned
Okay.
that before doing so, they shall publish. If they are published, they can go ahead. Realize. Any payment to realize shall be subject to the outcome.
Lord, that
He is only challenging the manner.
Lordship.
But the fact that once it comes within the municipal authority, the question of payment of tax automatically comes into the being.
Sure.
The late thing which the laziness or the sleepiness of the authority is concerned for not realizing the tax cannot take away the right of the authority to take. You should notice making it returnable by January 10th, 2024. Mr. S.R. Barua appears on behalf of the respondent number 1, 2, 3,
1, 2, 3,
and 6.
and 7.
6,
And 7 also.
6, and 7.
1, 2, 3, and
Extra copies of the writ petition be served upon him by 28/11/2023. As regards the respondent number 4 and 5, steps be taken by way of registered post as well as usual. The petitioner is further directed. The petitioners are further directed to take steps upon the said respondents, that is respondent number 4 and 5, by way of dusty, routed to the registry of this court and file an affidavit of service on or before the next day. The learned counsel appearing on behalf of the petitioner, who are 2 in number, appearing on behalf of the 2 petitions before this court, submits that the respondent number 4 and 5 have made assessments, have made assessments for the purpose of imposition of property tax upon the petitioners without following the mandate of section 79, 79B, 79A, the following the mandate of section 79, 79A, as well as 79F of the Assam Municipal Act 1956. The learned counsel submits that in order to determine the annual value of the holding, there has to be a classification of the holding in the manner set out in section 79A. He submits that subsection 5 of section 79A stipulates as to how stipulates that upon the approval of the committee, a municipality may from time to time publish the list of principal main roads and the main roads, and if necessary modify the list as may be decided by the committee. it is the specific submission of the learned counsel for the petitioner that there has been no approval of the committee as mentioned in subsection 5 of section 79A. He further submits that without that as the publication of the list of principal main roads and the main roads are essential for the purpose of carrying out the assessment in terms with section 79A bracket 2, comma. The assessment so made as is reflected in Annexure B to the writ petition is invalid, is contrary to the provisions of section 79A. He further submits that as per section 79A, the rate of taxes which have been determined in accordance with the provisions of the Act of 1956 has to be published by the respective municipal board or the town committee by issuing a public notice within a period of 3 months from the date of coming into force of the Assam Municipal Amendment Act 2012. He submits that in the instant case, the respondent authorities have been verbally demanding taxes from the petitioner without there being any publication being made in terms with section 79F. It is on the basis of the above, he further submits that the said Annexure B has not been notified or published, but the petitioners could obtain the same after making necessary inquiries in the office of the respondent number
4 and 5.
Respondent number 4. He therefore submits that pending that as a determination which have been sought has been made is contrary to section 79A and 79F, the imposition should be stayed till the respondent authorities determines the taxes after following the due procedure. I've also heard Mr. S.R. Bolwa, the learned counsel appearing on behalf of the respondent, who submits that the fact as to whether the Annexure B has been published or not is a question which can only be answered by the respondent number 4 and 5. This court, after giving an anxious consideration of the matter, is not inclined to stay the imposition of the taxes provided the mandate of section 79F have been complied with by the respondent number 4 and 5. Accordingly, this court directs the respondent number 4 and 5 not to impose any taxes upon the petitioner's hearing till the mandate of section 79F of making publication is duly complied with.
Extra copy along with the additional affidavit.
Oh, additional affidavit.
With the additional
তার
affidavit.
উপর একটু লিখে দিন। This court have also duly taken একটু লিখে তার আগতে extra copy দেওয়া করতে লিখে দিন। এই word extra copy আৰু এইটো notice দিব লাগিব। Justice service or feature like. This court have also taken note of that an additional affidavit has been filed by the petitioner. The same being an additional pleading should also being an additional pleading because the extra copies of such additional pleading has also to be served upon to Mr. S.R. Borua, the learned counsel appearing on behalf of the respondent, as well as such additional pleadings shall also form a part of the writ petition when service is taken upon the respondent numbers 4 and 5. Yes, Mr. Saikya, where are you? So, what case you have?
My lord, my case is there, my lord, clause 7.4.2, Roman 2, my lord. Assessment of charges payable.
Ah.
And the assessment for unauthorized excess connected load or unauthorized energy consumption shall be made at a rate twice of the applicable tariff in accordance with the provisions of section 126 of the Act, excluding the amount of bill related to the assessment period paid by the consumer at the applicable tariff.
Then it is in Roman 3, the methodology is given.
My lord, that is for the demand charge, my lord. As learned friend, my lord, pointed out yesterday, my lord, to the provision.
So this is for demand charge in excess of unauthorized load.
Yes,
This is
my lord.
there.
Here it is for connected load, my lord.
What is this connected load? This is unauthorized load.
Yes, my lord.
So this is what they have done.
No, my lord.
What no?
My lord, the provision to 7.4.2 Roman 2 has clear, my lord, regarding
That is why you
connected.
kindly see twice.
Twice.
Kindly see.
Yes, my lord.
Shall be made at the rate twice of the applicable tariff. Therefore, you see excess demand charge. Kindly see how it is done. 2 into how it is calculated. C denotes the demand charge applicable on the detected load as per the tariff. Into B denotes the number total connected load detected at the time of clear. Into N, number of months taken into a month of the fraction of a month minus the amount which you have already paid. That is how the calculation is. That is why twice. How do you find out? Just for example, yours is 697. Yours is connect load is 500. So what is to be paid is this 697 minus 500 is 197. It has to be multiplied by 2. That is the 2. First, it has to be multiplied to the amount, the tariff for the connected load into the number of months which day we are going to take. Then it has to be multiplied into 2 as per this 126.6 and minus it with D, the amount which you have already paid. This is why it is 2.
My lord,
The use of 2 is mentioned, that is why. Why they are making it 2? Otherwise, this is the charge. Without that 2, it is only C into B into N.
my lord, kindly allow me to withdraw liberty to file a press, my lord.
Huh?
With liberty to file a press, my lord.
Press?
A press. My lord,
Press no.
my lord, I have to
F
challenge
press
this
no.
provision, my lord.
Huh?
I have to challenge this provision, my lord.
You have to challenge this provision, then it is a different thing. It is a
provision no
different
longer
aspect of the
exists.
matter. But you, as of now, there is nothing. I don't find any illegality. I'm sitting out here exercising a tertiary jurisdiction. I don't find any illegality with that order. But the amount how it has been imposed upon you is right. So therefore, this question it has been done properly. Because this was done at a time when prior to coming into effect. Now it has come differently.
My lord, kindly.
You do one thing. You withdraw and you say that you will avail other remedies available under law. And then I say then you go and file review. The AERC may think about something and give you something. Otherwise, that is the only way out. Isn't it?
Yes, sir.
That is the only way. Otherwise, I don't find anything else. Because you see, if I am to dispose, I'll say this is okay. And once it is okay, your only way is go to the division bench. And you never know what is going to happen. When you are going to get the money, if the division bench allows it, then they won't leave you. They may go even to the Supreme Court. So there. So the only way out is this.
My lord, can I allow to withdraw to file
Approach
appropriate
the
petition before
appropriate
appropriate authority?
Mr. M. Sekia, the learned counsel appearing on behalf of the petitioner, submits that the petitioner may be permitted to withdraw the instant writ petition and approach the appropriate authority, approach the appropriate forum, if so advised. So, taking into account the said object, the said prayer of the petitioner have not been opposed by the counsel for the APDCL. Accordingly, the instant petition therefore stands closed on withdrawal. Full stop. It is, however, made clear that the withdrawal of the instant writ petition shall not prejudice the petitioner to approach the appropriate forum if otherwise permissible under law. Full stop. Interim order, if any, stands vacated.
Legible.
This is your book.
No, my lord.
এখন বানাই রাখতে এখন লাগি Yes, 42, 43. Whose matter is that? Yes.
Instance, my lord. Now, we have, my lord, here, challenge the, my lord.
You are issuing the retender.
Yes, my lord. Four-
Issued
In
setting.
respect of the one fishery, my lord,
Uh,
four standard was issued, my lord. First, second, third, fourth.
yeah. Why?
Why, my lord?
Actually, fault was on our part. There was a stay lordship. The department, the officials put up the file from the lower part, put up the file. We used to, while giving it, when we came to know that there is this stay was operating, so we called it, Lord.
So there was a stay for which you have recalled the retender.
Yes, Lordship. We actually, this is the fault of the somebody else, Lordship, in the department, Lordship. So we recalled it, we rectified it immediately whenever it came to notice of the MP, Lord.
Now, what is the order passed here?
Lordship, there is a, the fact is that, the issue is that,
With regard to the overall facts and circumstances, where the further processing of the retender notice shall remain state till the next.
So that is in respect to, my lord,
So you are challenging the retender
retender, my.
because you were the highest tender in the earlier one.
There are more than one highest bidder, but without bringing it to any logical conclusion, my lord, then second NIT was issued. We put to challenge the second NIT. That was stated by the Honorable High Court, my. Then, my lord, during the continuation of the stay, they came up with the third tender, third NIT, in respect of the same. We challenge it. Then they withdraw it. And thereafter, fourth tender in been issued, my lord. That is also a subject to challenge. Before your lordship is
we
another.
got everything, Lordship. Now, nothing, no tender is there. Lordship can adjudicate that matter, Lordship. Actually, the tender which was issued, it was all being withdrawn, Lordship. It was done mistakenly.
One is
On the
pending,
part
one
of
is
the-
pending, one has been statement. That
Which
in
one?
respect of the second petition.
Only stating, only this. Here, the fact is that, may I say, Lordship, the fact is that here, Lordship, here, there were three bidders, Lordship. One is found to be ineligible. So there is two bidders. So considering the fact only two bidders are there, we, after technical, we did not open the financial, we withdraw the tender process and gone for retender.
Why?
It's Lordship, that is, maybe it is around 1 year back, Lordship, this case was pending, Lordship, 1.5 years back.
Now, who is running the fish?
Nobody is, this khas, Lordship. So Lordship, we can open it, Lordship.
We do one thing. I allow you to run the fisheries privately and let these matters remain pending.
Yes, Lordship.
I think that is the best way. The government revenue is safe.
Lordship.
And we will decide these issues later on.
Well,
What I discussed with you.
And then if the petitioner is successful, very well, then we go as per the first tender.
Lordship.
What is your right, Mr. Ghosh, being the first tender,
My lord,
being a bidder?
my lord, there is no valid reason, nothing. For my lord, there is more than one successful bidder, my lord. And in terms of the decision of the honorable court, they say in the case of two successful bidder, my lord, you can just go for a retendering the tender, retendering, my lord, without that there is any fraud or there is any collusion between the parties. So that, my lord, they are not entitled to go for a retender when there is more than one bidder, highest bidder, valid bidder, my lord. That's what happened in this case, my lord. So what my response submission is this, my lord, they may go with open the first tender and my lord, so for other tender is concerned, depending on that, they may, my lord, issue the writ, whatever it is.
How
my lord.
many bidders have participated as per the first tender?
My lord, there are according to three bidders.
One was ineligible.
Bidder, two are the successful bidder, my lord. I am according to my instruction, I am the successful bidder, my lord.
You are the successful.
I'm the highest, my lord. I offered highest rate, according to my instruction.
He knows the second.
But what is your right? What is your right to say that yes, they have to go for that?
My lord, my respectful submission is this. If they
Yes,
want to-
understood. One thing. If it is a case that you have allegations and you can able to prove that allegation that yes, they in order that the third one became ineligible, or they wanted to give it to somebody,
Yes.
so they have cancelled
Yes.
and have gone again for a fresh bidder.
Ah.
Then if that is the case, yes, we can very well look into the question of
There is
the
no
thing.
reason whatsoever. At least I have right to know. At least they should know why my bid has been cancelled, my lord.
Not your bid, why the tender has been cancelled. Your bid has not been
Yes,
cancelled.
yes, right.
Yes, why?
Well, Lordship, because only there is
Have you
only,
filed affidavit?
Lordship, because they have in the, I have not filed affidavit only.
And why you mentioned the matter should be
Lordship,
taken
here,
up
Lordship,
urgently?
they have quoted the, kindly go to order dated 26, 2020.
In which writ petition?
40.
4053.
Yes, Lord. They have
Yes.
quoted only the order, the tender was paid, citing on judgment, Lord.
The last
Yes,
date of
this is the copy.
submission is fixed tomorrow without prejudice. The petitioner is also granted liberty to submit the advice. However, yes.
Only the judgment is a Devendas versus State of Assam.
Hmm.
So, my instruction is that if
Yes.
it is up to the Lordship, if it is so, Lordship, we can also open it, Lordship, with the two bidders, Lordship. But keeping pending, Lordship, it is becoming, government revenue is lost, Lordship.
Yes, that is what
That
I'm
is
only
my
concerned with
instruction is
that.
that if only the
I
law
have
point is
nothing to
there,
do
Lordship.
with other things.
If
You
only-
see, we may say anything,
No.
but the thing is that the government should not lose its revenue,
Lordship.
rightful revenue, obviously. Not that.
There is nothing nullified, Lordship. Only the judgment is the Devendra GLT 2018 5 GLT 1. Only on that part, the case was, the tender was paid, Lordship. Citing this judgment, Lord.
There are 20, 21 and 22.
Order.
But anyways, there's one division bench judgment of, I think, Justice Dhulia and Chief Justice Dhulia and another, and I think Justice Saikia. That was as regards the challenge to the cancellation of the tender. The single judge passed some order to the effect, and the matter went to the division bench, and the division bench said no, nothing doing. The authority have a right to cancel. But the only thing is whether it has been done to favor somebody
No.
is the question. No
Let-
means, am I going to trust your word for that, or is it on the basis of the affidavit of the
Nothing
person?
happens nowadays, Lord.
Huh?
Nothing happens like this, favoring somebody in AFDC, Lord.
If that is so, we would be, this court would have no work.
Lordship, we have not find any case also favoring somebody, I think. Even petitioner also not.
But Mr. Sharma,
Not-
if you are to give your reasons. You can't just say today that I am saying this is
No,
it.
Lordship, only the citing this judgment, Lordship. I don't have any objection also if Lordship allows it, considering this judgment to open the financial bit of the two tenderers. We don't also, only the stay is operating.
This is against one only. But have you said that you have cancelled and gone for a retender? And what has happened in respect to the retender? How many people have participated?
That was state, man. That was state, Lordship. That was not-
Retender has been stayed.
Lordship. Nobody
No, in the first order, there is an order that you shall be allowed to participate.
Yeah.
That's the order.
That
In the
is
first case, that is the order.
26, 2022 is the order, first.
This order, 26, 2022,
Yes.
since the last day
Yeah.
of submission of tender is fixed tomorrow, without prejudice to his right, the petitioner is also granted liberty to submit his tender if to advise. However, respondent shall not finalize the tender till the returnable date.
That is the.
So that is in respect to the tender dated 14th, dated what? Against 6/6/2022.
Yes.
This is against that tender. Okay. Then the next one, what is the order now?
There, my lord,
And Mr. Ghosh, did you submit in pursuance to that order?
I did not participate.
Okay. Then,
I
good.
did not, none of the subsequent NIT I participated.
Then there is another tender.
Then another tender, then
All been recalled, Lordship.
Having
then
regard
tender was recalled.
and not to finalize that order has been done, so you went for another tender.
Lordship, no, we recalled it, Lordship. It was a mistake on our part, Lordship. So
So you recalled it
Everything
and
is-
issued another tender.
Another.
Why? When the stay order was still operating, why?
Lordship, that is the fact. A mistake on the part of the office, Lordship. So whenever notice came, Lordship, file was signed, Lordship. Only in this fishery, Lord. Nothing to favor, Lordship. That mistake was done signing by the MD, Lord.
So this retender has been stayed again.
Everything is recalled, Lord.
You have recalled it.
Not this one. The tender where Mr. Ghosh client has appeared, that was still
That is there.
that is
But
there.
other two have been recalled.
Recalled.
You have recalled this tender.
Last one is not recalled, man.
No,
It was recalled.
Where is your instruction? Show me that this tender of
Page 48,
20/2022.
my lord, may 8, page 48 of WBC 8223 of 22.
Page 48.
Yes.
page 40. WC কিমান কৈছে 82%. Withdrawn. It was there, withdrawn. Withdrawn, Lord.
That is, my lord,
No. Have you withdrawn this tender, which has been the subject matter of challenge in 8226?
no, that has not been,
Not withdrawn.
that has not.
But Lordship, that was withdrawn, and for that they have come to this honorable court challenging that our withdrawal was wrong. Because
No, that's not it. This is not. After withdrawn, they again and plotted say another NIT in respect
that
of the
was-
same.
Here, which tender has been challenged? 4/2022 in the second writ petition.
In the second writ petition, my lord, we have challenged.
20/2022.
My lord, 17, 12, 22, my lord, NIT.
How many NITs are there? Do you? Where is that notice inviting tender of 20/2022?
Now, lordship will find it, my lord, 13th of October. page 50, my lord, of WPC 8226 of 22.
20.
Yes, please. That was not withdrawn, my.
Notice
17 to 22.
Then what happened?
This was also withdrawn,
Because
Lordship.
this
I
court,
Not received, you know.
this court stayed it.
Stayed it.
So what remains here? Nothing.
Nothing. Nobody participates.
Because the last date of submission was 3/1.
3/1.
And the court stayed it on 21/12. So nothing remains here. As regards the first tender, you did it on the basis that there were only two persons. One person was not there.
So
You did not open the financial
Yes,
bid.
yes. So we offer retender. If
And
Lordship,
on the basis of that judgment of Devendra,
yes. The Honorable
you, wherein it has been said that there is a difference between when a sole tender happens. If it was only one person submitting, it is a different aspect of the matter. They can go for retender.
Right.
But when there are many of which some have been disqualified and some are less, then there is only one tenderer left. Then it may not apply the same facts. But here there was only one in Devendra.
Left after, my lord. One. very
Only
little
one.
Left after.
Only one.
But there are more than one.
But there was only one.
Yes.
But in this case, there are two.
Two, my. Yes, sir. So they can also, my lord, be compared between the two with a higher.
leave it to
bidder,
your
they
Lordship,
can-
but I want the state to be. I want government revenue. Anything, Lordship, I leave it to your Lord.
No, if that is to be done, this court has to hold that the 20/2022 has to go.
Lordship. No, yes,
Then the second tender has to go
Lordship.
because you have already withdrawn.
Lordship.
Second tender you have withdrawn.
Lordship.
Where there is a stay,
Lordship.
you have withdrawn that.
Lordship.
So the remaining is the first one.
First one. Only first one is remaining.
So you want to go open it. That is your lookout. if
Lordship,
you
I
want to pay that.
cannot, Lordship, if Lordship, after going,
But have you but you must have cancelled it.
we, for opening, we have already cancelled it.
You have to cancel it. But how do I, unless the cancellation is not set aside, how do I do it?
Yes, Lordship, that cannot be. We have already cancelled the tender. Yes, Lordship.
And have you challenged the cancellation of the tender in the second writ petition? First one? Mr. P. Sharma, why in all your cases setting aside the impugned tender? You have not challenged the cancellation.
My lord, cancellation order has not been published, nothing, my. We have not get in touch with the order. They only simply retender.
But how do I set aside the cancellation then? You have only gone for a retender. The retender has been withdrawn. Then how do I do? If the retender has been withdrawn and the cancellation remains, how do I overcome that problem?
My lord, there is no cancellation as such, my lord. Now they are
No,
saying that,
There has to be a cancellation. How can they go for a retender? Tell me.
that is how they can.
If you are there on the other side, this will be your first submission. Then
Yes, Lord.
why don't you submit? Or you know that you are the highest one.
My lord, that is as far instruction, my lord. If they going not want to let them open, my lord, the first one.
But cancellation.
No, Mr. Ghosh, one thing. For me to distinguish this judgment is very easy. Because here it ended with one, but there are two. So obviously it cannot be said that they were wrong. Can very well be said that they are not wrong. So because this court is not going to look into any other thing, only on the fairness of the action.
Yeah.
And the fairness of the action is as to whether they wanted to give some benefit to some and they deprive the petitioner. Here, there were two persons. The two persons are one person have not challenged, the other person is before this court. Unless you show that you are, and you can't say because the financial bid has not been opened. And the moment you say that you are the highest, without the financial bid, then something must be fishy in the fishery.
Let the both the bid be opened by now.
What?
Yes.
The financial bid is also open. My land.
Open?
No, Lordship. Not open, Lordship. Financial bid, how can I win? It is on record, Lordship.
Okay, you do one thing. You file your affidavit. The reasons why you have gone for the second tender and as whether the financial bid has been opened up.
And interim,
What interim? Interim is there. I'm not touching anything till that. First, we'll see that because you see, there is it cannot be. You have to take some responsibility by filing an affidavit. And if your fishery department does not want to do, or the AFDC doesn't want to, I can't help it. So, upon hearing the learned counsels for the parties, this court is of the opinion that merely making statements before this court, the reasons for cancellation of the first tender and then going ahead with the second tender, which have been put to challenge in WPC number 4053/2022, and thereafter cancelling the same and issuing the third tender, which had been put to challenge in WPC number 8226/2022, be decided on the basis of just verbal instructions. The same has to be, the reasons have to be assigned by way of an affidavit filed by the Managing Director of the AFDC. List the matter when you want it urgent.
urgency, Lordship. Any day, Lord, within 2 days, I will, by Monday, I will.
Okay. List the matter again on 29th of November 2023. The affidavit be filed on 28th of November 2023. And in the said affidavit, it should also be indicated as to whether the financial bid in respect to tender number what?
One.
1/2022.
Yes.
Was opened. This is this one. No, Rupobili. Have you gone for best tender for Rupobili?
No.
Rupai Bali?
No, Lordship. This
No, I'm asking you. Have you gone for fresh tender for Rupai Bali? That also you get your instruction.
Bible.
The learned counsel, further to that, it is also, the respondent shall also indicate as to whether the respondents have gone for fresh tender in respect of Rupai Bali Bil Kachar, Bastandi Anua Kachar, wherein also there remained only 2 successful bidders after the technical evaluation.
Lord. I think they had gone for it.
Eh?
I think they have gone for retender.
Let us see, because that is the reason. If that is the reason, then obviously, because there also 2 remains, and here also 2 remains.
That's for and one
Then
year
we
back also,
will-
this matter, these things happen, Lord. Okay? So retender was there, Lord.
Let us see. 28, huh?
20. Okay, by 20.
Is the matter on
Production list, item number 1.
We'll take this as the last item.
Item 21.
Lordship, 1 minute. Lordship. Just 1 minute.
Which one?
Okay. Lordship, the fact of the case is that our it is
I know your case is as regards the duplicate case diary.
31.
None appears on behalf of any of the parties. List the matter. Do it.
Item 22 to 26.
Lord, may I kindly produce the last one? Order dated for 27/9/2020.
Yes, report.
Well, the new committee has been constituted and they have submitted the report and it is pending with the authority.
The Learned Council appearing on behalf of Mr. A. Bhattacharjee, Learned Council appearing on behalf of the Revenue and Disaster Management Department submit that pursuant to the order dated 27/9/2023, the report has been submitted before the
It says authority.
Submitted before the Revenue and Disaster Management Department and the authority is presently and the authority requires another 3 weeks' time to take a stand in the matter. The said instructions so placed is kept on record and marked with a letter X. List the matter in the first week of January on list the matter on 5th of January 2023, on which date Mr. A. Bhattacharjee, Learned Council appearing on behalf of the Revenue and Disaster Management Department shall further apprise as to what decision the committee has, the department has taken on the report to submit.
37.
Rather on last question, your lordship directed the
counsel for the municipal board to obtain instruction.
Yes. Who is the municipal board?
Lordship, I am appearing.
Yes. What is your basis on which? What is on the year?
Lordship, we have received instruction today. Lordship, as per instruction, after receiving the complaint from the private respondent, Lordship, we issue a notice to hold on the construction till disposal of the complaint, Lordship, and ask to submit an representation.
Which is the
Reply.
improved notice?
Your notice is at page 24.
Hmm?
Page 24.
Page 26, Lordship.
Yes, thereafter 26. First, I was permitted to build a temporary shed, and thereafter that was stopped.
Yes.
After that,
And the petitioner thereupon sought for and filed an application seeking
Yes.
permission.
Yes.
What have you done to that?
they filed an application, Lordship.
Ah.
After the then chairman of Jorhat Municipal Board asked the respondent to file a reply of the same if they have any stay order of the court.
Then,
But then Lordship, no response from their end.
then
Then cases, they filed this case and it is pending. No decision
letter
has been
pending
taken.
from 2017.
Lordship, no decision has been taken.
How can you do that? Yes, Mr. Monto, what do you have to say? These are all your private disputes.
Yes, my lord, your lordship kindly see,
Why are you approaching the Jorhat Municipal Board?
because my lord, he has given a permission to the my land, my lord. Without my lord,
That will be a case of a civil case. Why are you not getting an
No, I-
injunction?
no, my lord, your lordship kindly see, the permission, your lordship kindly see, permission, my lord. Permission, my lord, annexure D is the permission, my lord.
Annexure?
Annexure
17.
Yes.
70.
Ah.
Annexure D.
Yes.
So that, my lord, Jorhat Municipal given a permission, my lord, in 407 and 408. 407, he has no land, my lord. That is my land, my lord. And that's why I made an
But
application.
407, 4107.
Sorry, 4107 and 4108.
Hmm.
And very interestingly, my lord, in the lead petition, my lord, he is near the mentioned the DAG number. Your lordship kindly see only my pata number, my lord.
Pata
that-
number is what?
Pata number 334. He entire lead petition, he mentioned only pata number, my lord. Your lordship kindly.
No,
Yes.
no. Understood. But what business does the Jorhat Municipal Board has to?
My lord.
You want that he should not construct?
No,
to
my
get
lord.
an injunction?
No, I made an application that yes, your lordship kindly see my application, my lord, page 21. At least, my lord, I may be heard, my lord. So my complaint should be heard, my lord. So that's why, my lord, issue notice to him, my lord,
No,
making.
no, he
inquiry.
has submitted and you have not filed a reply for the last 4 years, 5 years, or 6 years.
No, we have not filed reply, my
That is
lord.
what she is
No.
waiting.
This is my complaint. My lord, I do not know, my lord. Let them file an affidavit, my lord. I haven't received because I filed my affidavit and that is not been denied by everything is not been denied by him also. Because
What have you said? It is your land.
your lordship,
No, you say that it is your land.
no, my lord, I said that, my lord, the land which was permission was granted, my lord, it is not his land. He's not been denied.
Whose land it is?
My land, my lord.
To me?
My lord, may kindly see paragraph 5 of his affidavit. He also admits that part of that land, the ownership is with me. Kindly see
With
paragraph 5.
regard to the statement that the deponent denies that the deponent exercises states that the father of the petitioner had not purchased any land in tag number 4107 of Iman of Iman. And rather he had purchased 10 liters out of Iman in tag number Iman by deposit to sale. On the other hand, mutation case is found that the seller used the cup of land in tag number and there is no question of purchasing 10.5 liters.
Where
Therefore, he says that merely because my vendor had
supposedly 2 lessons of land, so I could not have purchased 10.5. That is the crux of his content.
No, my lord, I
That be
said
the
that
case, my lord, it
40
ought to have been sent for trial.
before giving permission, my lord, at least my lord, municipality board has to be, my lord, make an inquiry.
Basically, what has happened, my lord, he has challenged the mutation that was granted in my favor in the year 2006. He challenged that mutation belatedly in the year 2016, after 10 years. Knowing fully well that by that time, possibly he cannot bring a suit, he files an application before the revenue authority, and in the garb of that application, this complaint is filed before the municipal court. Your lordship will kindly see his affidavit at page 32, annexure 5. That is the order which he has annexed.
Annexure?
Annexure 5, page 32 of his affidavit, additional affidavit. He challenges the mutation granted in favor of the writ petitioner in the year 2006, in the year 2016, accompanied by an application for condonation of delay. And it seems from this that on the same day, perhaps the condonation was allowed. Thereafter, this exercise is undertaken. We are in possession of the land from 1971, having purchased it from his predecessor. Now, he disputes that the predecessor did not have particular share, as paragraph 5 suggests that his predecessor did not have that much of share in the land, so as to enable sale in my favor. If that is the way content similar, they have to go before the trial court.
Your lordship kindly see the my lord circle officer report, my lord. Page 29, my lord. Page 29, my lord. There is a report of the circle officer, my lord. Of affidavit, my lord. Page 29.
But I don't understand, Mr. Dotto. On what basis are you saying that he doesn't have the limitation?
No, he filed an application 2016.
No, if it is his land, he can very well file a suit
Yes.
for recovery at any point of time.
Filing a suit is on a different.
Yes.
He is asking for cancellation of mutation.
It's another different
He's
aspect
asking
of the
for
matter.
cancellation of
Cancellation of mutation is another aspect, but he can very well file a suit
Yes.
for
No, I'm not saying
recovery
that this
for
suit
recovery of possession and for as well as for restraining any construction.
Yes.
But
That
what
he
is
can-
this
that he can
business
do.
of it?
But in the garb of seeking a cancellation of mutation, he files this application before the. And what business municipal board has got to deny permission unless and until there is violation of building bylaws? And that is also a temporary shade for which the permission was granted. It is
But
not a-
show me, your land has been mutated in 4107.
07 and 08.
Where is it? Show me the document.
So that document is not on record, but the circle officer's report, which they have enclosed in the affidavit, my lord, that indicates that 4107 and 4108, the names were mutated. Your lordship will kindly see at page
So
29.
you must have purchased it.
Yes, that was our case.
Very well. So how did you purchase it?
That was my predecessor purchased it from his predecessor in interest.
How?
That was initially page 22, annexure G, your lordship will see the possession.
Annexure
certificate.
C,
Yes, annexure G, page 22 of my writ petition.
page 22. Yes.
With due reference to the subject referred to above, the land situated at Jorhat East Avenue Circle so-and-so, Meadipatta number 4107 and 08, land measuring so-and-so 1 kata 10.5 lesa is in the name of the applicant and in the name of Srimati Chandana Ghosh, 10 lesa land is registered. According to the papers, the name of the applicants have been incorporated by 4 different mutation kits. Applicants are using 9 lasers of land for their shop premises as per the last Mandal report. The boundary of the aforestated 9 lasers of land is, then boundary is given and his land comes to the east and south of our land. According to the last Mandal's report, the applicant's home is situated on Dak number 4107 and 08. After measuring 1 kara 12 lesser land is found. 4 boundaries, then a boundary is given. This is dated 28th of February 2018.
The location of land.
Only thing that they complain of is that in the mutation process, some discrepancies have taken place, and supposedly some portion of their land, in respect of some portion of their land, my name has been mutated. That is their complaint before
But
the.
where is your document of title for 4107 and 4108?
Our title deed we have not annexed in the writ petition. But
Enclosed.
But-
Bring it on record.
Yes.
We'll see on what basis or whether your mutation order has been enclosed.
no, mutation order has not been enclosed, but that is the only order which they have challenged now.
And they may challenge, that's a different thing, but first we have to see that, yes, because there are 2 aspects. One aspect, for the first thing, taking any action, this court will can interfere. That this is a civil dispute between both parties, this court. But the second prayer, for consideration of your representation, this court can't do that.
Yes, unless and until I can show title.
That is the only thing. Because then I have to show that, say that till the mutation is not satisfied, that you cannot go into the decide the question of civil dispute. It is purely a civil dispute.
Yeah.
So, but without that, it becomes very difficult. Don't you think so?
Yes.
Mr. S. Dr. The learned counsel, senior counsel appearing on behalf of the petitioner seeks for an accommodation in the matter to file an additional affidavit bringing on record the documents of title of the petitioner as well as any mutation order made in favor of the petitioner pertaining to doc number 4107 and 4108 of included in KP Pata number 334.
Correct.
Miss appearing for respondent number 1 have produced the instructions in terms with the order dated 15/11/2023. I have produced the instructions, have produced the records in pursuance to the order dated 15/11/2023 and submits that pursuant to the representation so submitted by the petitioner, the Jorhat Municipal Board have granted of various opportunities to the respondent, private respondent, to file the reply, and no reply has yet been filed, for which there has been a delay in disposal of the representation of the petition. Huh? What? Okay. The records to produce, when can you file it?
Within a week.
The records to produce is returned to be again produced on 8th of December 2023. In the meantime, the petitioner would be, if so advised, would be at liberty to file the additional affidavit.
Can it be on 11th of December? 8th, I have come.
Okay, on 11th of December.
Pleasure.
How long? Done?
No. Proposal not,
17.5 lakhs.
proposal not yet received from Deputy Commissioner.
Huh?
Proposal has not been received from Deputy Commissioner.
And I get to inform you that
District Commissioner to brief.
Deputy Commissioner has submitted the proposal on 28/2/2017.
No, therefore, there is an instruction, Lordship may peruse 26/9/23. Lordship has kept it on record perhaps.
26/9/2023.
23.
Ah. It
That's
was
the last
like
paragraph,
to
mine.
inform you that the government path plan of Swens was recommended in favor of Swenso. Again, the same proposal by Swenso was reported to the commission for final approval. In the meantime, letter was received from government to re-examine the proposal and Swenso and for submission report by office letter dated for onward submission. Yes, and thereafter you have not submitted. What is wrong?
No. Lordship, let me take instruction regarding this. Why they did not submit?
This can't happen. We impose cost upon both of you.
Can you give a last one?
Both of you. District Commissioner Dhubri. Okay, we compose cost of 5,000 each to District Commissioner Dhubri and the Revenue Secretary for delaying the matter. Unnecessarily, the matter has been delayed. This court have duly taken note of that by various orders, there has been directions to the respondent authorities to take steps as regards the proposal which was submitted as far back as by the Deputy Commissioner Dhubri on 28/2/2017 for settlement of 17.5 acres of land pertaining to Dag number 771 part of Revenue Village, Ananda Nagar, under Bilasipara Revenue Circle of the Dhubri district in favor of the petitioner. On the last occasion when the matter was listed, that is on 27/9/2023, an instruction was placed to the effect that on 26/9/2023, there was a direction to that on 30/7/2020, there was a direction by the Revenue Department to the Deputy District Commissioner Dhubri for the purpose of submission of the report to the government. On 27/9/2023, an instruction was placed before this court by the Additional District Commissioner, Dhubri, to the effect that the government, by the communication dated 11/2/2020, directed that the proposal be re-examined and as per the latest checklist issued by Government Circular number ECF.700/2017/42 dated 13/4/2018. And as such, the same was sent to the Subdivisional Officer, Civil, Bilasipara, by the communication dated 30/7/2020 for onward submission to the government. Today, when the matter has been listed, Mr. A. Bhattacharjee, the learned counsel appearing on behalf of the Revenue and Disaster Management Department, submit that the Revenue and Disaster Management Department is not in a position to decide or take a call on the proposal, taking into account that the respondent, that the district commissioner, as well as the subdivisional officer, Bilasipara, the district commissioner Dhubri, as well as the subdivisional officer Bilasipara, have not submitted the fresh proposal as directed by the communication dated 11/2/2020. This court have seen that more than 3 years have passed by. Then also there has been no action on the part of the respondent number 3 and 4. This court therefore fixes the matter again on 18th of December 2023, on which date the respondent, more particularly the respondent number 4 and 5, are directed to apprise this court as to whether the report have been submitted before the Revenue and Disaster Management Department. This court further is of the opinion that if there is any further delay, costs shall be imposed upon the respondent number 3 and 4 in their personal capacity, which shall be imposed upon the respondent number 3 and 4, which shall be thereupon shall be imposed upon the respondent number 3 and 4.
29.
The instruction so placed is kept on record and marked with the letter Y. Why go you? Yes, Mr. Chaudhary.
Yes. My lord, the oil India authority was supposed to.
Oh, this one.
Sorry, I
Yes.
will say, yes.
Got it?
The instructions are here, my lord. We are working in his favor. Now, provided-
Understood. That you were working in their favor. You have stated the same thing on 22/9.
Yes.
And that thing has
Yes.
been repeated every time.
Lordship
How
will
does it
see
make?
that there's one provision under the reconstitution guidelines
Hmm.
which provides that an advertisement can be issued calling for objection from anyone who is interested in the retail outlet, provided they have been a partner earlier or so. Now, certain documents are asked from them. Once they come, the advertisement will take place, and after 30 days from the date of advertisement, the entire access will be carried out. The reconstitution policies which they have annexed is incomplete, my lord. There's one clause L8 which speaks about that particular time after.
Have
the
you
advertisement.
mentioned to them? Have you informed the
The
petitioner?
copy has been, just now it has been given.
Mr.
Anyway, my lord, we'll
P.
comply with this requirement.
Mr. P. Bhardas, the learned counsel appearing on behalf of the
IOC.
IOCL, submits that there has been that the respondent authorities are taking steps, but but on accounts of inadequacy of certain documents and an advertisement to be issued by the dealer, the said formalities could not be completed. Mr. K. Chaudhary, the learned senior counsel, submits that during the course of the day, the said instructions have been placed before him, and he shall instruct his assisting counsel to instruct the petitioner accordingly.
Yes.
List the matter again on
It has to be in any case after 6 weeks, my lord, because 30
6
days will
weeks.
be notice.
list the matter again
Can-
on 29th of January 2024 for further instruction.
Obliged.
Not 29th of January, let it be after 5th of February.
Okay, 5th of February,
After 5th of February.
7th of February.
Thank you.
31.
Instructions are called for.
My lord, I'm appearing for respondent number 4. My copy of the restriction was served on us, but without the annexure. My lord, I will request him to.
My
Okay.
goodness, Mr. Mitra.
My lord, this is the.
Doesn't look nice.
I got it here.
This I see. What have been, when did you appear?
My lord,
When did you first appear before the court?
this is the first time.
You are appearing today.
Yes, ma'am. Yes, my lord.
The notice has been served only today.
No, it was served earlier. I filed my worker number earlier, my lord.
When?
I have to check out. I think. Probably 6 months back. More than 6 months. 6 months back, I think.
6 months back. When the matter was listed on the last occasion, where were you?
Oh, my lord, I was out of station at that time. There was a letter.
Then,
That
what is all these things?
No,
You
my-
have not been served with the lectures and all.
no, my
Nothing
lord.
doing. Forget about that. Yes, what is your case? I'm not going to consider that such type of thing. These are things which are to be raised in the appellate forum. Yes, then
Lordship, on our last occasion, I was directed to obtain instruction.
list the matter on which the Mr. Elboder appearing on behalf shall obtain is the instruction. The petitioner herein agree by the inaction on the part of the respondent in not taking steps in respect to the application filed by seeking ownership on when reveals on the record that this court had notice. Yes, what
But as per my instruction, they have made a party circle officer dispute lordship. This is not fall under the dispute revenue circle.
okay?
It's fall under the Sondrapur revenue circle. They did not make the party of the Sondrapur revenue circle. Whenever we ask the instruction, there is no available in the record, so they have the return back.
Where did
They-
you
they have-
where did you file the application?
The deputy commissioner.
Then get the
Deputy commissioner.
what is the circle officer going to do? What about the deputy? commissioner?
Instruction have to be come from the revenue, there is Sondrapur revenue circle.
Why not the deputy commissioner? They have his simple case is that he has filed an application on the 22 to 25 of the transfer this 1971 Act, and that has not been processed. That's all. What is wrong? Why do you need instructions to the effect to the effect? Ask the deputy commissioner and get the instruction. That is it. Nothing further. He is not asking that this court should decide and give him the ownership rights. No. He only says he should have directing the respondent to declare the ownership so and so, so and so, so and so. Have you filed an application?
Yes, sir.
That application has to be considered. That's all.
As per law. But application is to be considered as per direction. Maybe.
And if somebody is agreed,
Agreed, then I could go to higher authority. But it is pending last 3 years.
I gave you only an opportunity to obtain instructions for the reason that if you obtain the instructions, then in that case, this court can dispose it of without saying that and
Lordship,
thinking
Lordship.
honestly that the DC Kamrup was doing some actions or taking some steps. Didn't know that you are going to go to the
Lordship,
circle officer
I'm-
for that. When did you submit the application?
4/3/2020.
Where?
DC office.
Where is your application? Where is the undersigned? Yes, 40, 20,
26 page.
2020.
2020.
Any number given?
No, the receipt.
Oh, there the problem arises. It is before this was during COVID times, nearby the COVID times. So this is being done under the central receipt thing.
Yeah.
And they must have lost it, must have. Anyway, you do one thing.
Let-
You
let-
submit a fresh one.
Press one.
And when you submit a fresh one, this court will direct the deputy commissioner to take a decision within 6 months. I think that is the win-win.
It will be.
And Mr. Mitro need not ask for the any. Okay, the instant petition has been filed by the petitioner, being agreed by the inaction on the part of the deputy commissioner, Kamrup Metro, for not taking any steps in respect to the application filed by the petitioner for application filed by the petitioner under section 23 Roman 1 of the Assam Temporarily Settled Areas bracket Tenancy Act 1971, thereby declaring the ownership rights, thereby granting the ownership rights to the petitioner in respect to the plot of land measuring 3 bighas 6 lecher, 0 katha 6 lecher, covered by Dag number 434, old 279, new, included in Patta number FS Grant 1 under Revenue Village, Panighati, under Muza, Beltola, within the Deshpur Revenue Circle. This court have duly perused the said application, which was filed on 4/3/2020 in Form 5 as per Rule 9 of the Assam. Rule 9 of what? And as per Rule 9. Full stop. it seems this court, by an order dated 5/2/2021, had issued notice till date. There has been no instructions received in spite of the order dated 18/10/2023. Be that as it may, Mr. J. Hending, the learned counsel appearing on behalf of the Deputy Commissioner, Kamrup Metro, submits that as the said application have been submitted in the central receipt section of the Office of the Deputy Commissioner, Kamrup Metro, the same application may not have reached the authority concerned, for which thus no appropriate action could be taken. He submits that the petitioner may be permitted to file a fresh application and the Deputy Commissioner, Kamrup Metro, be directed to decide the said application in accordance with the provisions within a time frame. This court, having taken note of the fact that the petitioner have filed an application claiming ownership right over the land referred to here in above, but the same having not yet been processed, is of the opinion that it would be in the interest of justice that the petitioner be given a liberty to file a fresh application before the Deputy Commissioner, Kamrup Metro, claiming ownership rights as per the provisions of the Act of 1971. Agote Act of 71. This court directs the Deputy Commissioner, Kamrup Metro, either by himself or through an additional Deputy Commissioner, take up the said application so filed by the petitioner, if so filed by the petitioner, and dispose of the same by giving an opportunity of hearing to the respondent number 4. The said application, if so filed, be preferably disposed of within a period of 6 months from the date of submission of the said application, along with a certified copy of the instant order. With the above, the instant petition stands disposed.
529 is depicted at 72.
72, take on rules on Assam temporarily settled area tenancy rules of 1970.
32 and
Form
33.
5, Rule 9 of
In this matter, why the previous order, we were directed to file an additional affidavit, whereby we were supposed to actually make a certain clarification. Well, we are yet to receive that clarification.
Oh, I remember. What happened?
So I pray for some time.
Why?
I'm yet to receive the clarification.
My lord, petitioner is a widow, my lord. She's suffering.
One last topic.
Hardship, my lord. With her 3 minor children.
Eh?
3 minor children.
Minor children?
Otherwise, everything is clear, my lord.
Not very clear, my lord. If my lord will have a look at the affidavits, my lord.
This court, by an order dated 9/10/2023, sought for specific instructions from Mr. N.K. Devnath, the learned standing counsel of the PNRD, and I had also directed to file an affidavit in both the writ petitions by 17/11/2023, clarifying the position. Mr. N.K. Devnath, the learned standing counsel, submits a final opportunity be granted to the petitioner, to the respondent, so that the affidavit could be filed. Taking into account the above, this court grants a final opportunity to the PNRD department to file the affidavit by 13th of December 2023. List the matter again on 19th of December.
34.
Yes, Mr. Gulda.
Lordship, we have filed an affidavit today, so it's not on record, Lordship. Today
Okay,
only we have filed.
Mr. What is this matter? What is this affidavit business?
This is for, Lordship, CCIS scheme, Central Capital Investment Subsidy.
Hmm.
So what has happened, he has filed the application and documents have been sent. Then like when the spot verification was required to be done, the officials went to his place, that unit, then the machineries were not installed there.
Oh.
And so that's why that GM concerned, he could not recommend it to the SLC. So it was not placed before SLC. That is our stand here. Lordship.
Okay. Mr. A. Kolkar, the learned counsel, appearing on behalf of the Industries and Commerce Department, submits that the affidavit has been filed by the said department today. The said affidavit, however, being not a part of the record, the registry is directed to bring on record the said affidavit. List the matter again on 3rd of January 2023. In the meantime, the petitioner would be at liberty to file the reply.
35.
Oh, 74.
Land acquisition, Lordship. 74, Lordship.
Yes, what is your instruction? Mr. Sole, who is the finance?
Lordship, I am appearing.
What is your instruction?
Lordship, so far as my oral instruction is concerned, Finance Department has not yet received any such proposal.
It has been sent from water resource.
Water resource.
They are claiming, Lordship.
Who is paying for water resource? Yes, why haven't you sent it? What is this every time? You say you have sent it, he says he's not got it. Last time also he has not got it. Then what is it? This can't go in this manner. A person's property has been taken and you have water resource. Give him back the land. It can't happen like this. He's a 74-year-old person. No, because on the earlier occasion also the instruction is that you have already sent the thing to the finance department. Why the finance has not received it? Is there any block out there, the cyber block? It can't happen like this. A person who is 74-year-old has been asked to run from pillar to post to get his due. And this is not today. This is a case of 20 years back. Return back the land to him. No, I think the better off. You return back the land. You want the land back?
Yes, sir.
Yes. Return back the land. No. We impose a cost. We'll ask this person to appear in person. No, nothing. Enough is enough. Who is the secretary? We'll ask the secretary. Who is the secretary at the department? Water Resource Department, Commissioner and Secretary. No, this can't happen. No, sorry. No, nothing doing. Mr. P. Naik, the learned counsel appearing on behalf of the Finance Department, submits that the Finance Department has not received any proposal from the Water Resource Department. This court finds it relevant to refer to the orders dated 16/10/2023 as well as 18/11/2023, wherein there has been submissions being made by the council appearing on behalf of the Water Resource Department that the proposal has been sent to the Finance Department. The said either the submission made by the there cannot be two contradictory stand in as much as it is the specific submission made by the standing council on 16/10/2023 by Mr. S.R.M. Das, the Standing Counsel for the Water Resource Department on 16/10/23, as well as by Mr. C. Sharma, the Standing Counsel of the Water Resource Department, that the proposal had been sent to the Finance Department. Today, Ms. Ardeka, the learned Standing Counsel for the Water Resource Department, has no instructions on that said aspect. Under such circumstances, it is the opinion of this court, taking into account that the petitioner have been deprived of his dues, deprived of his land acquisition compensation for the last more than 20 years, fixes the matter again on 29th of November 2023 at 10:15 a.m., on which date the Commissioner and Secretary to the Government of Assam Water Resource Department is directed to appear through video link before this court. You provide the video link. Ask him to appear. Else, if he doesn't appear, then at 2, I'm asking him to be present personally. It can't happen
36.
like this. Yes, Mr. Das.
Here, I'm the contractor, PWC contractor, where my grievance is that from my running account bill, they have deducted forest royalty from my running account bill. PWC contractor, I represent and I say there are judgments of this court. This court, we said you can't deduct it unless it has to be specifically in the contract or it has to be backed by statutory.
There was one judgment passed by Brother Chaudhary.
Yes, that judgment is there, and that judgment might distinguish also. The additional application appeared, and they cited the judgment of Muslim Ali also, which is the same petitioner, and that has been. They said, no, that is different altogether, which you are relying on.
Where there was a direction to the PWD for payment of the the royalty amount or something.
The judgment which may have cited one judgment.
My lord, that whatever my learned senior has referred to Justice Chaudhary's judgment, it went to appeal.
Then
appeal, my lord, it was upheld that Forest Department, as well as the Administrative Department, can insist for production of a forest royalty clearance certificate, wherein the contractor has to show the materials used was royalty paid. Only upon production of those documents, my lord, he is entitled for any kind of refund or, my lord, otherwise, my lord.
Where?
I am giving him that.
Oh, yeah, it is there. Oh, no. This is a different one.
This is totally fresh, man. This is really.
Oh,
read appeal number 258 of 22, order dated.
NC does light so and so, NC does light.
Yeah,
Who moved up the day?
Read appeal, my lords. It was moved by Mr. U.K. Goswami, a railway contractor, my lords. Similar
Why did he move?
he sought certain clarifications. He sought that we cannot, departments cannot insist because Muslim Ali was taken into account, and my lord, relying on the same Muslim Ali, it was said that it was agitated that there was no clause in the contract, so you cannot insist upon payment. But in that case, my lord, departments involved had only sought for the source, forest royalty clearance certificate, to ascertain that the materials sourced are from royalty paid sources, in which my lord, the honorable division bench did not interfere. It upheld the view that we can ask for forest royalty clearance certificates. No, overall, GS visa pura code pura hai.
This appeal has been gone into at the behest of the contractor, taking into account that there was a direction by you
Yes, my lord.
for issuance of a forest royalty clearance certificate.
Certificate.
And why was he agree with the brother Chaudhary's order?
He, as per I can recall, my lords, he wanted to clarify a few points of Justice Chaudhary's order, that whether it's permissible, because the issue was same, that he claims that the materials were sourced from open market. No department can insist, my lords, for forest clearance certificate, because they were brought from open market, not from government sources.
No. There is a reason why this is not. But whether it was a term of your contract, term of your notice inviting tender, that there would be a forest clearance certificate required.
Clarified by my lord senior. It was a PWD contract.
No, because that judgment,
My lord, there was a clause.
there was a clause. That is why he went.
Yes. That is a
Yes. So that
now
has
PWD has to clarify.
Here, in this case, it was not in the terms and conditions of the contract. That's our
Then
case. And my
how
lord,
can you
the
impose that?
judgment which he went before the appellate court, I
Directing
remember,
not to be
that was the
issued,
terms and
directing
conditions of the
refund of the
contract.
amount of appeasement which was deducted from the bills of the petitioner towards forest royalty and rupees 2 lakhs which is withheld out of the petitioner's claim for the work in question. Then how do you bring that?
No, my lord, then a question comes, my lord. There, it might not be a part of a contract, but by virtue of contract law, my lords, contract act, can a contract be made, my lord, breach of a statute? There's a statute in force.
Are you saying that the contract was bad?
I am
So
not
any
commenting-
consequences of the contract will be bad.
I am not.
So you return back whatever he has done.
I'm not commenting
Mr.
on that.
Mr. Gogoi, don't make these submissions.
Because my
You make these submissions everywhere,
no, my lord,
outside, not
there is
here.
a statute.
And no, Mr. Gogoi, don't make those type of submissions. The fact that if the contract categorically mandates, yes, you can, because if you see paragraph number 3 of the judgment of the division bench,
my lords,
the core question which this court is required to adjudicate in this batch of appeals is regarding the legality and validity of the notice dated 8/2/2000 issued by the Northeast Railway requiring the appellant to provide the forest clearance certificate regarding 5 components of the work order in question, that so and so. The letter mentions that the forest royalty certificate of the quantity of materials used by the contractor would have to be submitted before clearing the next bill submitted towards the construction work awarded by so and so. The appellant questioned the legality and validity of the aforesaid order by filing the captioned bunch of writ petitions, which came to be disposed of by learned single judge by the order day. In conclusion, the same ordinary in absence of any contract condition, when a contractor is unable to produce a certificate showing the use of forest footage on which the royalty has been collected, the recovery from the real AR cannot be made. So this clause has not been interfered with.
then in that case, my lord will come to Muslim Ali judgment at page 90 of the petition.
The main submission of the learned counsel for the appellant in reference to the condition number 13.2 of the contract was that as ordinary earth was not covered under clause 13.2 of the tender, the employee railways was not at liberty to demand the forest royalty certificates from the appellant regarding the so and so. However, we are in the least impressed by the said submission by the simple reason that clause 13.2 referred to supra is not exhaustive in its operation because it only refers to sand, stone, and timber in a generic sense as covered under so and so. The governing phrase of the said clause is forest produced. Examples in the so and so, so and so, so and so. It has been held by the division bench of this court in so and so that the ordinary earth even extracted from pakka land and on non-forest area is liable to levy of royalty. And undeniably ordinary earth has been used by the contractor for carrying out the work in question. Proof of royalty being paid would have to be provided by the contractor to the employer before the bills can be paid. In this background, the notice dated so and so issued by the employer to the appellant herein requiring them to present the forest that cannot be termed to be illegal or unjustified in any manner. So there was a term there.
There's a term.
Here there is no term.
My lord, there may not be a term. My lord, but Muslim Ali judgment, lordship will see page.
Why
90.
should I say Muslim Ali?
No, there is a my lord.
When
there-
the judgment, when the judgment of
No.
the Justice Chaudhary has not been interfered with.
It says, my lord, unless
That man, that law that he has duly appreciate. When that whatever may be, just for example, a 7 judges or 10 judges judgment is being referred to and expressed by the 5 judges of the Supreme Court or even a 3 judges of the Supreme Court, stating that this is the law. This court is bound by that. Now, when after considering Muslim Ali judgment, which is a division bench judgment, the single judge, the coordinate bench have categorically held that this is what I mean. So this court have to otherwise hold that this is wrong.
no, my lord.
Why should I?
I am accepting Muslim Ali. There's no
Then your
dispute, my
Muslim
lord.
Ali was
Muslim-
considered. Why should I?
In Muslim Ali judgment, there is a question to this answer to this.
You have
dispute, my
not.
lord.
No. Why haven't you filed an appeal against that? You have attained that finality.
No. Muslim Ali for a moment, my lord.
Mr. Gogoi,
Muslim
these
Ali
type
for
of
a moment, my lord.
conditions would not.
Muslim Ali says something, my lord. I am relying on Muslim Ali only to justify my claim.
Here, the judgment of Justice Chaudhary makes it very clear that in absence of any contract condition where a contractor
Yes,
is
yes.
unable to produce a certificate showing the use of forest produce on which the royalty has been collected, the recovery from the bill against the forest royalty cannot be made. How can I help you?
Then because Muslim Ali says, my lords, no
Muslim Ali may say, but Muslim Ali was taken into consideration by the single judge.
appropriation of money from the contractual dues
This
is from
court is not going to do all these things. You have a contract condition, very well you can do. But if you don't have a contract condition, you can't help it.
But my lord, what if a
Without
statute is
certainty
there, my
of the
lord?
fact that royalty is payable on the materials used by the contractor, the same cannot be recovered without giving an opportunity to the contractor before deduction. Have you done that?
That's PWD, my lord.
Well, whoever me, in those contracts where such conditions are incorporated, the employer shall be within its competence and jurisdiction to recover the forest royalty from the bill. Condition is there. And therefore, what the division bench held, that term was there in that contract.
Yes.
And as such, it is there. So here you don't have. Show me that the condition is there.
But kindly see
There may not be express
page
provisions, my
86
lord.
of the division bench judgment, what your lordship has expressed. Kindly see which is settled law by the division bench. Same party. Kindly see 86. Same what your lordship has said.
Page?
See, 86.
Of?
86 of my writ petition. 86. Kindly see para 60. Kindly see para 60.
This is what
86.
judgment. Vipuria. Oh no, Muslim Ali.
Muslim Ali.
That is
Division
what
bench.
he is referring to.
Yes, para 16. Para
The
16.
officer provides the bills of contractor engaged in construction work of timber and they are using will not be paid until the same is not a condition so therefore have no party.
Kindly, my lord, learned single judge accepted. Division bench accepted the the consideration of the learned.
But the same
How they
judgment,
are
paragraph
coming
18.
From
Same
20
judgment, matlab paragraph, page 90, paragraph 18. There is or,
We
my
are
lord.
in agreement with the views expressed by the learned. No appropriation of money from the contractual fees is permissible unless backed by statutory provisions or by express provisions contained in the contract agreement, binding the parties to the contract. In absence thereof, such deductions could be unauthorized. Yes, yes.
There is no provision. I'm assuming, my lord. But my lord,
But
there's a
don't assume
statute.
and make
My lord,
submission.
there's a statute.
What's
The
it?
word is used or, my lord, unless
What
backed
is
by
the statutory
my lord.
provision?
My lord,
What is the statutory provision which entitles them to deduct? That is the statutory provision.
my lord, this is the some minor rules are there.
Minor minimum rules
Also-
does that empower them to deduct?
No, my lord, they have to ask us, will provide the royalty certificate that these materials sourced were from royalty paid sources. Then after we clarify, my lord, that payment is open.
no.
There's a statute in operation, my lord. There's Assam, there's a notification under forest regulations. There's also Assam minor rules. Whoever consumes, my lord, has to pay a royalty. That is my contention, my lord. Otherwise,
Whoever issued what?
whoever, my lord, consumes, my lord, these minerals, my lord, whoever consumes has to pay royalty. So now the question here is, did the contractor, my lord, lifted the materials used by him for a legal royalty paid source? That is a fact-finding exercise. They'll write back to us. We'll verify if that he will produce his certificates or challans, then he's entitled to everything, my lord.
Because the power to deduct has to be sourced from a statute to them or the contract.
They have to justify.
No, either
My lord.
from a statute. That is why it has been mentioned. The power to deduct has to from the force from a statute. Just for example, you are today paying your income tax and you must have submitted your bill to the forest department. They pay you after deducting a tax. This is done under the TDS, under the Income Tax Act. This is a power to deduct. Or this is a portion or an incidence which can be advanced. Or what is a TDS? TDS is an advance receipt of the tax.
My lord.
So by way of an agreement, you can very well put it.
My lord.
But that is why that is the meaning of the statutory provision. There has to be a power by a statute. Where is the power to the PWD? You can have many reasons, whatever may be. That's a different thing. You can issue them a letter that you have used it, so kindly pay us. Your liberty.
Exactly, I'm pointing out that, my lord.
No, you can very well
Yes.
ask them. But how do they have the power to deduct? Because that power has to be stemmed from the minor minerals, giving them the power to deduct. No, that power is not there. That is why paragraph 18 has been mentioned. Isn't it, Mr. Das?
Yes. This 22 onward, this petition. All the time I learned friends.
No,
said,
I was on a
it's different.
totally
All-
different
I tried
context.
to
I
explain.
abandoned that prayer.
tried to
I was
explain.
on a to be different footing. I was on the maintenance of this question. Maintenance of this petition
In the
because
single
I
bench.
had raised a question as regards the relief claimed by him under 226 is a public law remedy or a private law remedy.
Why?
Because, my lord, these are these are not statutory contracts. Only statutory contracts, in my humble understanding, could be assailed or agitated before a court. I had a few judgments in my favor. Now I'm abandoning that. We are on a different footing. But whereas, my lord, Kerala SCB was there, even our high court has my lord, has a division bench judgment. There are only statutory contracts and statutory contracts and disputes arising therefrom can be, my lord, agitated in 226. And the relief claim by the petitioner, my lord, is a totally private law remedy, my lord.
In the words of
I'm leaving
learned
it now. I'm
counsel,
abandoning. I'm not pressing it anymore.
in the words of a learned counsel out here, nowadays, the maintainability of a writ petition is not only based upon a horizontal one, it can be, no, not only on a vertical one, can also be in a horizontal.
And recently, my lord,
In view
there
of
was,
that judgment, where
another
it has
judgment
been
came, my lord.
mentioned a maintainability of a repetition against even a private person.
Because my lord, a new judgment came, MP Power Management in 16/12/22 Sanjay Kishan call. So I was also going through that. So it was very bulky, so I had to abandon. Otherwise, I was depending on Kerala SCB judgment of 2000, State of Manipur judgment 2005. Other judgments are the Escort Current versus LIC, my lords.
Oh, those judgments are there, but whatever may be.
So
the
I'm
question
abandoning
is-
my.
The question is the power. No. What? You see, those are not statutory contract, but here is the question of the power of the, when a power of the PWD has been put to challenge, a power of the statutory
My lord.
authority has been put to challenge. Why not a writ? It's not a question of fact, it is a question of law. And if you see the Godrej Sarali judgment, wherein the Supreme Court says, when it's a question, a pure question of law, then it cannot be.
Well, I'm just not this.
Anyways, don't spoil any further time. We discuss the directors people
PWD has
to
to. PWD has to.
PWD, what will he say?
Bring
He has
all
nothing to
this-
say. He has to follow that. He has nothing to say. What will he say? He cannot. Let him show him a statutory provision by which he can. It has to stem. Like, just for example, in his agreement with him, there will be a power to collect, to deduct tax. That power will be there to him.
One judgment is there, Lordship, we are bound by that judgment. But Lordship will take note only one condition in the agreement.
Yes.
43. That condition has also been gone through by the other courts. One condition your Lordship again like
40?
43 page number. Clause 41 tax. 41.1. The rate quoted by the contractor shall be deemed to be inclusive of the sales and other levies, duties, royalties, rates, toll taxes of central and state government, local authorities, and authorities that the contractor will have paid for the performance of this contract.
Yeah.
So far as that royalty part is concerned, that is part of the tender value. That you will have to pay. There is no exemption.
No.
But
No, Mr. Counsel, no. Whether, if it is the tender value, if he has to pay the royalty, then he has to pay. But it will be all inclusive. Tax, royalty, cess, service tax, GST, whatever will be inclusive of his bid. Now, you have a power to collect tax,
yes,
deduct tax, you can deduct
yes, we deduct yes.
GST, VAT, whatever may be, you can very well do it. But you have no power to deduct the, even as per this.
Next line, Your Honor.
Yes, that is what I've said. The power
The
will perform
employer
such
will
duties in
perform
regard to
such
deduction of
duties
such
in regard to the
taxes
deduction of the source
as per the applicable law. You don't have the power to deduct tax. This deduction of tax you are going to do, if you are doing it under the VAT or the GST, there is a specific provision. If you are doing to do as per the income tax, there is a specific provision, 174.
Now, Lord, to put page 67.
Page?
One bill now. Page 67. This is bill dated 11/8/2020. Next page, your Lord, to put page 68. Lord, to put see the last column. Last 4-5 lines. Necessary forest royalty, sales tax, VAT, etc. for his work may be recovered from this bill. No other recovery of this bill. Article C.
No, this you have
Page
done it.
number 70.
Yes.
Down below, Lordship, date of signature of the contractor supplier.
Then?
So it is not that he has not been given the opportunity. It's that
No, I'm not on opportunity, but we have the power. First, we have the power to deduct. You don't have the power to deduct.
whether we have the authority.
That is what he has said. That is the judgment of the
Ultimately, the petitioner will have to pay the royalty. Somebody
Is the PWD going to take their case
We are not.
Let them do.
What we are
Let them issue notice to him and collect whatever may be. You issue notice. That is, there is no stopping you from doing it.
it.
In that case, my lord,
From every department, from every contractor, taking the information from the contractor, it will be a difficulty for the forest.
because my lord,
That is why
You
this-
you can't help it. You ask either the parliament or your or this mine and mineral rules amend it.
my lord,
Amend it, giving your power, you the power for deduction.
my lord, we have to ask them. There's a notification in power. Please, my
You
lord.
can ask to one thing. You
We
can
have to
ask
go-
them.
We cannot go after them. We have to come after them, my lord, the
You
department.
ask whoever you. But the fact is, question of deduction cannot arise. You can very well ask them that you have to pay. Because you see, the reason why I'm saying it, as I was yesterday, you were there, na?
Yes, I was
That excise matter.
Yes, yes.
It is here the point of charge is the question. The point of charge in view of the clause 41, which 43, which he has referred,
41.1.
41 or whatever he has referred, is all inclusive. Meaning thereby, he is bound to pay the royalty. His rate is bound by the royalty, tax, cess, GST, VST, whatever may be, he has to pay. So under such circumstances, you cannot demand them. You can very well demand them. Or you may ask their information, but you may demand them because they are to doing it. Because it is his rate which is being quoted. In fact, yesterday that judgment, that judgment which I am dealing it, that one, the Hosai municipality, Hailakandi one. You were there, na PWD. Yes. You were there in one matter, na PWD. Where that GST has been challenged. Do you remember? So there, this is the judgment which is coming out. Once it is inclusive, you cannot touch that. Not you. He cannot ask for that. The only power a person can get in excess is by 64A of the Sale of Goods Act. And in the Sale of Goods Act gives a power, but subject to the contract. Now here the contract out here categorically says that this will be done in this manner, that it will be all inclusive, that tomorrow, just for example, the royalty becomes, which was 10 rupees, becomes 150 rupees. But he has to perform the contract at 150 rupees or not, his rate cannot be. This is what is the mandate.
That has been explained by this court, whatever your lordship, page 84, this 41.1. Kindly see page 84, para 11. Exactly same, 84, para 11. Kindly see para 11, my. Under clause 7.2, tender the contractors was not required to obtain any consent by employer so and so. The standard specified in the contract. Clause 41.1 of the tender provide the rate quoted by contractors will be deemed to be inclusive of the sales and other levies, duties, royalty, cess, toll, taxes, etc. Contractor will have to pay for the personal contract and the employer will perform such duty in regard to deduction of such taxes as source as per applicable law. As per clause 39.1 of tender document, payments shall be adjusted on account of deduction for advance payments so and so. Now, parent 12, from the cumulative reading of the above clause, it will be evident there is a contractual presumption in favor of the contractor. Rate quoted shall be deemed to be inclusive of your lordship. And that has been, my lord, the learned single judge in RN, that they went before that court and said that no, the Muslim Ali, it is distinguished. The court said, how you can say that's a follow division bench judgment. We have to follow the judgment. And it should be in terms of the contract. Well, that the judgment of this Durga Krishna stone, it was a term of the contract.
And help you.
My only anxiety was there, my lord. I just wanted to know that when a contract is signed, my lord, it may not contain some provision, but regulating those provisions, there is always statute in place.
Which
statute is always
Which
is
statute
there,
is
my lord.
there?
But just a general question. I was
No,
putting myself
therefore
there.
I'm asking which statute?
There's a statute, my lord, Assam Minor
That's my
Minerals
exact,
is
no,
there.
no. That's my Assam Minor Mineral.
Give
Gives them the power
to
to them to deduct. No.
my lord.
That is why I was saying, see, 174 of the Income Tax Act. 174 of the Income Tax Act, that gives the power to deduct your tax. See the VAT Act, it gives the power to deduct it. Or by way of a contract, you can change the position. Where he may say that, yes, this I'm going to deduct. That is also not there. That is why it has been mentioned, if it is in the contract, it is stipulated. Then they can.
You can just hope, my lord, they amend this contract, insert it.
Yes.
Then we'll
Anyway,
see, my lord.
Disposed of,
My lord.
allowing it.
But there is a provision under section 5 of the Assam Minor Mineral Concession Rule. Suppose the PW department, I am a contractor in the PW department. My contractor says there is no material available. So PWD will give a requisition to Forest Department. Forest Department will give me royalty, then I have to pay.
No, that's a different.
That I have to pay.
That
That's
is
an
why I
exception
say
carved out
Right,
for
right, right.
gentlemen.
that if there is a royalty to be paid, the Forest Department can very well issue notice, taking into account clause 41, wherein it says it will be inclusive, and for that basis you are saying that he has used the earth. You can very well issue notice to him.
My lord.
37.
Oh, good. Fine. ठीक है.
Obliged.
Obliged, my lord.
Yes,
Lordship, this petitioner is before this court is the unregistered trade union. And the application was presented for registration of the trade union under the Trade Union Act 1926.
then
Then the application was kept in the cold storage near about 1 year. No positive response was given. Thereafter, I have approached the Honorable Court with a prayer to direct them to register my trade union. But they have filed the affidavit in opposition, and they have taken stand that in terms of the section 9 of the Trade Union Act, the sufficient member who are enrolled as a member of the organization, they are
okay,
not.
okay, we'll do it. We'll have it some other day. Is the matter on when pleadings are complete?
Yes, 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 sir.
Taking into account that the pleadings are complete, let's the matter again on 5th of January 2024. On which date an attempt shall be made to dispose of the.
Lordship, I have another fear that I have another matter, item number 57. It is also under the industrial law. Can it be taken on the same date? It is hearing.
The 57 on
57. Obliged, sir.
I'm taking the list on the request to the.
My lord, affidavit is ready, my lord, only to person to come and sign, my lord. So maybe
Okay.
fix some.
You ask the learned additional senior government advocate submit that the affidavit is ready and same would be filed within a day or two.
My lord, it's from, my lord, maybe 1 week time, maybe that.
Within a day or two. List the matter again on 13th of December 2023. In the meantime, the affidavit be filed.
Let's- Similar, my lord, next month.
39.
Similar. Deeply obliged.
These are contractual due.
My lord, it's my lord, verification has already been completed, my lord, now, my lord. Deeply obliged.
Today is too late in the day to dispose of it. Okay, your turn.
The non-payment of contractual bill, my lord. Bill amount was 21,20,000 and 483, my lord. Part payment was made, 9,40,318 was paid, and remaining amount 11,80,000. Completion certificate was issued, my lord, and similar, this case relates to Water Resource Department. Similar other writ petition, my lord, has been disposed of. I have annexed the order also.
Where?
My lord, the relevant portion, but you will find
There is 181.
178. Relevant. 181 also, this is another matter. 178 is the main direction was issued, madam.
This is there, but here Jal Shakti is there.
Yes, your lordship.
Who is appear for the central government? Ah, who is appearing?
Oh,
Because the direction has to be given as per that judgment of Justice Sham. The
Lordship.
direction has to be given to
As
Jal
per
Shakti.
my instruction also, the water resource department has already released the state share against the scheme. However, for balance amount in respect of the petitioner, payment will be made as and when central assistance is received from Jal Shakti.
That is what. Anyway, we'll take it up some other day. Please the matter again on the 13th of December 2023.
But can it be after 16, my lord?
Okay. Let's this matter again on 12th of January 2023. 24.
Lordship, regarding item number 35, your lordship, lordship has directed commissioner and secretary water resource.
Really.
Lordship, actually, water resource department has no commissioner and
What do they have?
chief engineer, your lordship.
No commissioner, no secretary.
No, your lordship,
The chief engineer.
chief engineer.
Itu order to chief engineer.
41.
41 is also same, my lord.
Vacated. Yes, one motion was there, Mr. Sakia. Whose motion was this?
Initial motion, well, perfect is
Yes. Show me that motion. Yes.
Production list 1.
What is your case?
Yes, but Lordship, I have a electricity connection. I am paying the bills regularly. I have annexed the bills also. In the bill of page at page 39, the bill of November, Lordship would see page 39, bill detail, outstanding has been shown as 65,524. Lordship, from
Outstanding, yeah.
page 21,
Wait. Page 21.
from page 21 to 39, I have annexed all the previous bills. Such amount was not shown on outstanding. Due date is 23rd November. Now my husband had a different, who expired on 2011, had a different connection with a different consumer number. That has a outstanding bill. Now we have already appealed for settlement of that bill, that is under process. But
There is an outstanding out there of 63,000.
no, that bill, Lordship would see the legal notice. The legal notice is at page 16.
16.
16. Legal notice at page 18. Sorry, Lordship. The type copy is at page 16. Here outstanding, it is to my late husband on 9/9/22. But Lordship would see at page 15, my husband has died way back in the 26/2/2011. I have annexed the certificate.
And what is this meter?
This different meter, different connection, different consumer number.
What is the number out here?
Yes.
Meter number
number is
693,182. Consumer number 1631 lakh. Consumer.
Consumer number is 50 different.
Yes, Mr. Pathak, what is this outstanding amount?
Your Lordship, perhaps one thing which I could not ascertain from the petition, I could not get instructions because today being a state holiday, the offices are closed. And whether the consumer, the meter which the husband was using, and the wife is now using, whether it is for the same premises or not.
The premises is the same. Premises is the same because it's my house. in 2000, as per my instruction in 2021, we took a new connection in my name after the death of the husband, and we
Why
are
was the connection was in your husband's name? In respect to a building belonging to you?
no lordship. Earlier it was connection was
Earlier, whose building it was?
no lordship. Firstly, it is a building of Narayan Dhar. Now it is transferred to Kalpana Dhar.
Building was whose? Earlier, building was whose? Your husband's.
Husband.
And he had that meter.
He meter with a separate consumer.
No, no.
Yes.
Did you have 2 meters at that point of time?
One meter.
Only 1 meter. Now, the house being the building remains the same.
Yes, proper.
That meter is no longer there.
No.
And that meter, now you have got a fresh meter.
Yes, fresh meter.
And now this amount is being claimed from you.
Yes, in my bill.
So then, what is wrong?
No, lordship. Firstly, no
No problem.
Lordship would just see there is a limitation under the electricity. Limitation
what
is
is the
2
limit?
years.
Huh?
2 years is the limitation
For what?
for recovery of old due. There is a limitation in that.
Where is it?
Lordship would
Electricity Act.
see. And I have not defaulted. How they can insert it in my bill? Lordship? That is, some notice has to be given.
Show me. Where is the limitation?
Yes.
No.
43, page 43, Lordship. It's a
No, where is the act? Not in the act.
Yes, it is there in the act also.
Where?
Yes. 56. 56 2. Notwithstanding anything
Any other law.
contained in any other law from
Yes. When did your husband die?
11.
2011.
2011. Since then, no
And when
notice.
did you change the meter?
We have applied for a new connection that was granted in 2020.
So you had the meter till 2020.
I had the meter till 2020.
And it was, and what was shown as areas in the meter?
Areas, Lordship, as per my instruction, in 2020, it was some 22,000. There was a bill.
But you were using it. Were you not using it for the 9 years?
Lordship, but there was no intimation. The areas were not shown. Lordship.
22,000 was that. Did you pay that 22,000?
Lordship, we because he was dead, from that time we are trying to negotiate. Lordship.
No. If you are trying to negotiate, that means you are acknowledging the payment. Then how do you apply for 56(2)?
Lordship, for these last years, they were not claiming it after that. We are in the new connection, we are paying the bill. Now the problem is that I have a separate
So
connection.
you mean to
separate
say
meter.
one day, a person has a huge amount, and then after his wife applies, the earlier period becomes useless.
No, firstly, Lordship, in the same name, there cannot be two electricity connections. It is a totally different connection. They can recover from, if
In
at
the
all, they
na-
can recover from me as recovered dues of that consumer for any non-payment of that consumer number.
What happens if there is a huge amount that a person dies, then the electricity will say that no, I can't recover.
No, they initially disconnected my that they had the duty to disconnect. Firstly, now secondly,
They let them, if they let them fulfill their duty.
no, they have to disconnect the Narayan Dhas electricity connection.
That they have already done. Now they cannot, are you still having that meter?
No, Lord.
Then
But I have a separate connection, separate meter.
understood.
There is no
You
change
have,
in my meter.
you
How
have
they
done,
can
you
put-
have.
No, Lordship, I just trying to make my point. How they can put the bill of my husband in my bill?
Not the husband on your bill. It's not the separate meter. I am understanding. It was all along your husband's name. The meter was there. You were enjoying for 9 years that meter. And
was
one
a
fine
separate
day,
consumer
getting the meter, now you're not paying it.
No, Lordship, that was a separate consumer number.
Maybe, but it was all along in your husband's name for 9 years.
The meter is also different. With a connection, there is a
Obviously,
meter.
you will now get a different meter because you have got a new
But
connection.
But recovery also, there is a procedure. Recovery, they cannot, if Lordship will see the legal notice. Lordship will see the legal notice. In the legal notice, they say that they will initiate civil or criminal proceeding. They do not say in the legal notice that they will disconnect. Lordship, I'll point it out at least
So you mean to say when a notice has been issued once, you have to follow only that, even if the statute permits others?
No, Lordship, but statute does not permit recovery after 2 years.
Statute permits disconnection.
No, Lordship, after 2 years, it does not permit recovery for.
Otherwise, there is an
disconnection
alternative
for-
remedy for these kind of issues there. In the,
Alternative.
there is a forum especially set up
Okay.
for adjudication of these kind of issues.
Where?
It's the Consumer Grievance Redressal Forum set up under the Act, Your Lordship, and ARCRC.
Every
is
15
published
days,
it.
they won't disconnect. Go there.
Yes.
Go there. Thereafter being agreed, you know what to do.
There is a appellate provision also.
And there is a 15 days notice period also that they have not given.
What?
15 days notice also it is there in the
All
statute.
these you raised there.
But-
Mr. B, sir, the instant writ petition has been filed by the petitioner being aggrieved by the action of the respondent authorities in demanding an amount of rupees 65,524.90 from the petitioner, which as per the petitioner was not permissible. From a perusal of the materials on record, it reveals that the house wherein the electric connection presently exists was originally in the name of the husband of the petitioner. And the husband of the petitioner was issued a service connection by the APDC, by the ACB.
APDC, Assam Power Distribution Company.
Then,
From 2003 onward,
2003 onward, that they have become APDC.
There was
initially
by
by
the APDCL.
ACBL.
The husband of the petitioner expired in the year 2011. Subsequent to the husband of the petitioner expiring, the house of the petitioner, husband of the petitioner, stood vested upon the petitioner. As per the law of inheritance. It is the further case of the petitioner that the electric meter which was provided by the APDCL to the husband of the petitioner was continued till the year 2020. And thereupon, a fresh meter was issued to the petitioner bearing consumer number 033 Saita 0 125877. The petitioners thereupon have been issued bills regularly by the respondent APDCL authority, and the petitioner have also been regularly paying the said bills. To the utter surprise of the petitioner, on the when did you receive this bill?
On 17 November.
On 17th of November 2023, the petitioner received a bill dated 8/11/2023, whereby the petitioner was directed to make payment of an amount of rupees 67,000. 67,102, 112 on or before 23rd of November 2023. To the further surprise of the petitioner, an amount of rupees 65,524.90 was shown as arrears. Although it is the case of the petitioner that since the petitioner was given the connection, the petitioner had paid all the dues, all the demands so made in respect to the said meter. It is also seen from a perusal of the petition that there was a legal notice issued by one Samir Saha, advocate, on behalf of the subdivisional engineer Bizni Electrical Division APDCL, wherein it has been mentioned, dated 9/9/2022, wherein it has been mentioned that in respect to consumer number 33 Saita 081631, having meter number 693182, there was a due of an amount of rupees 55,080. The same notice was issued to in the name of the husband of the petitioner, who had expired in the year 2011. It is the case of the petitioner, therefore, that as the same meter in the case of the petitioner, that the dues pertaining to that meter, which belonged to the husband of the petitioner, cannot be transferred to the meter of the petitioner. Which have been done a meter of the petitioner and shown as outstanding. The learned counsel for the petitioner further submits that there is further a limitation for disconnection as stipulated under section 56(2) of the Electricity Act 2003. And as such, there cannot be a disconnection on the basis of a dues in respect of another meter. I've heard Mr. K.P. Pathak, the learned counsel standing counsel appearing on behalf of the APDCL, who submits that merely because a fresh meter has been issued in the name of the petitioner, in view of the house now standing in the name of the petitioner, would not absolve the petitioner of the dues which was pending in respect to the meter which she used till 2020. Be it as it may, the learned counsel further submits that there are various factual adjudications to be carried out. As to whether the petitioner herein was duly intimated about the dues pertaining to the consumer number 33 cited 081631, which the petitioner was using till 2020. He submitted that there is a redressal forum specifically designed to take care of such disputes, which is the
state level consumer grievance redressal forum.
State level consumer redressal
Forum. Grievance redressal forum.
Redressal forum, wherein the petitioner can very well approach this court. Having heard the learned counsels for the parties, is of the opinion that the above facts, the opinion that for deciding the matter, it will require adjudication of various facts. Insofar as to whether the petitioner or the husband, as to whether the petitioner had duly intimated about the death of the husband, and as to whether the petitioner or her husband was issued any notice, any bill in respect to the consumer number 33 cited 081631. This court also is of the opinion that, taking into account that there is an effective and efficacious remedy available, the petitioner may be given the liberty to approach the said forum within the said forum, instead of entertaining the instant petition. This court also cannot be unmindful of the fact that if that while granting the liberty to the petitioner to approach the redressal forum, the petitioner is also required to be protected till the petitioner approaches the redressal forum. Under such circumstances, this court grants the liberty to the petitioner to approach the Hague Consumer Redressal Forum. This court further imposes a stay on the bill dated 8/11/2023 in respect to the consumer number, number to 0330 12587 for an amount of rupees insofar as the amount of rupees 65,524.90 for a period of 15 days from till today. As such, so in that view of the matter, it is clarified that the respondent epidicial authority shall not initiate any action for disconnection of the electricity for 15 days from today. As regards if the amount of rupees 65,524.90 is not paid, this court further directs, further observed that in the circumstance the petitioner approaches the redressal forum within the period of this 15 days, the redressal forum shall duly consider the same and consider the case of the petition with the above the obliged. Any urgency?
I have items 48, 49, 50. So long pending bills lordship may fix a date for
Long pending?
Contextual things. So the date may be fixed lordship. Right.
You do one thing.
Lord.
I will ask these people, the registry, list the matter. I won't fix a date.
Can we fix the date with our brother?
No, you can fix a date. No, I'm not saying that. If these type of matters comes up now, one day this can be finished it off. Unnecessary these types of matters every time, because you see the motion matters today got a better chance. Yours are old pending matters which could not be. Anyways, I'll do one thing. I'll fix a date. Give a date next year, January.
Item 55, it was for a granting of an interim order today. It is come for orders, all services are complete as part of it. Not lordship may fix it by admission for interim orders. Lordship, what has happened? I was the LOI holder. Without any notice, my LOI has been cancelled. Now it has been given to a person who is not even the leader in the process.
And you didn't get a stay.
Lots of what has happened. I did not make one necessary party. Therefore, I have made it now, and it is ready for admission.
53. 53.
55.
Steps are complete.
Complete.
Service is complete.
Complete.
55 को लिखी थी वो. As the service is complete, list the matter for admission in the second week of December.
Lordship, Lordship, may I please, Lordship, item number 46, Lordship. Finally fix this matter on 29th, having Monday to Wednesday, Lordship.
Why?
In this one interim order, we are
29.
obliged, Lordship.
Any interim orders are there, ask them to get it extended, fix it in the month of December and we extend. If there is an interim.